My lords, one dispute of Advocates Association, my lords. Advocates Association, Bagalkot, my lords. It's a dispute of Advocates Association, my lords. Members were expelled. The same they have complained before the DRO, my lords. DRO proceed to passes an inquiry order, my lords. Inquiry was fixed on 27th, my lords. Meanwhile, this honorable court have seized the matter 2:30, my lords. Because inquiry is fixed on 27th, my lords. This honorable court have already seized the matter in some other petition. Please, they have on resolution. There is already an interim stay, my lords. Interim order, my lords. No, they are not considering that order. If we given so inquiry is fixed on 27th, my lords. We are seeking 2:30, my lords.
Pending matter. Pending madam. Pending a fresh.
Fresh matter.
My lords, with your lordship's kind permission, my lords, this is a fresh matter, my lords, wherein the petitioner is a solar power project, my lords, has been supplying power for 10 years to GESCOM. There is some disturbance that is being caused by the authorities, my lords, with respect to fencing. Your lordships may have it at 2:30, my lords.
Tomorrow.
My lords, there is some urgency.
Urgency.
The threat of they're trying to remove the fencing and take the property, my lords.
State is involved, they need to get instructions, no 230, tomorrow.
Position warrant has.
Election 230 kodi.
One matter 230 millard.
Why?
Deputy Commissioner has imposed a penalty of rupees 20 lakh millard and they know that millard. No, the matter is
Hello,
covered,
sir.
but please, come on.
ಏನಆಗಲ್ಲ ಕೊಡಿ.
With your lordship, kind permission.
Wait, BC 1 minute, sir.
My lords, pending matters regarding my lord. No, my lords, urgency,
No.
they have called for the, my lords, tender, new tender. My tender license, fair for license has cancelled by the deputy director. I will intimate the government advocates.
Tomorrow.
Tomorrow fresh matters, my lord. It was,
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಬರುತ್ತೆ ಕೊಡಿ.
no, my lords,
ನಾಳೆ ಎಲ್ಲಿ ಬರುತ್ತೆ ಗೊತ್ತಿಲ್ಲ.
ಒಂದು
ಮೆಮೊಲಿ
ತಿಂಗ್ಳಿಗೆ-
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಂತ ಬರೆಯಕ್ಕಾಗಲ್ಲ.
ಒಂದು
ಇಲ್ಲ ಅಂದ್ರೆ I'll take it on Monday.
Monday, my lord, please, Monday.
ಕೊಡಿ.
Lordship, one submission.
Fresh matter.
230, my lord. The matter is covered judgment, promotion.
Tomorrow.
With your lordship, kind permission.
Compulsory termination of his class.
Off.
The petitioner has been compulsory, my lord, has been made retired.
Eh?
Compulsory retirement order has been passed.
ಪೆಂಡಿಂಗ್
Full of that.
ಸ್ಪೆಷಲ್ ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಕೊಡ್ತಾರೆ ಫೈನಲ್ ಆರ್ಡರ್ಗೆ ಕೊಡಿ ನಾಳೆ.
Lordship,
Another matter, my lord, the illegal construction being put up, 230.
Why?
My lord, they are
According
not
to you it is illegal. We'll don't know tomorrow.
petitioner working as a guest.
ನಾಳೆ ಬರ್ಲಿ. ಏನು ಲೀಗಲ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಎಂಟ್ರಿ ಮಾಡಲ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್
Lordship. Petitioner working as a guest lecturer, covered judgment is 230.
ನಾಳೆ.
Four matter.
With your lordship.
Four matter.
With your lordship, kind permission.
1 minute, sir. VC, I'll get back on.
Four matter pertains to the Bangalore bench. This is memo is moving by the state, my lord. For vacating stay, and the last date, ಹೌದು. ಬೆಂಗಳೂರಿಂದ ಫೈಲ್ ಬಂದಿರಲಿಲ್ಲ.
27.
The petitioner was assaulted inside the police station in front of the police inspector.
Pending fresh
Fresh matter, your lordship.
tomorrow.
Net recovery related, tomorrow, my lords.
Yes, VC, tell me.
My lord, today serial number 151. Yesterday, your lordship was pleased to dispose of the matter, similar matter, my lord, serial number 25 and 25.2, my lord. The same matters, my lord. My only submission that my statement of objections already filed in both all the three matters may kindly be disposed in considering my statement of objections.
ಯಾವ್ದು Sadiq?
Yesterday, madam, 25.1, 25 and 25.1. Yes, madam.
151 or 155?
151, madam, 151. This is a similar matter. Yesterday, your lordship was pleased to dispose of the matter.
We'll see.
I was in
Yes.
with
All right, yes,
my,
next.
With my lord's kind permission, may I make a mention,
Yes.
my lords? My lords, the fresh matter that we have filed, TRES, where yesterday they have initiated coercive action contrary to the Supreme Court specific directions. My lords, remember this Mineral Development Authority area development decision of royalty.
Tomorrow.
My lords, could I request it for day after, my lords?
Day after, we don't know. Tomorrow I can take. Day after, we don't know. Yes.
Okay, tomorrow, my lords. Fine, I'll be there. Grateful.
My lord, this is regarding the Competition Commission matter listed on 27 November.
Yes, madam, it would be there.
My lord, I'm inquiring on behalf of the learned Attorney General whether your lordship will take up the matter in Bangalore
Yes,
or
yes,
not.
madam. Yes, madam. I'll take it at Bangalore itself.
Grateful, my lord.
Attorney General is coming?
Yes, my lord, he would be coming.
Number 1, Shivraj Siballaki, Jay Gachinmat.
So petitioner, kindly take it after 2 weeks, my lord.
Why?
It's a matter, my lord, sought for extension of time
For
regarding allotment of sites.
Huh.
Last occasion, my lord, to adjourn to explore, my lord, if
My lords, your lordship's judgment on this point. my lords.
My judgment itself.
that is consistent.
Supreme Court, following Supreme Court judgment.
Take chance, my lord.
Like inordinate delay of my lords.
Worship has already taken a view. I understand.
No, Supreme Court.
I
I was of
agree.
the view that
Based
some
on that, my
sympathy
lord,
should be shown, but Supreme Court has reversed everything.
I agree. my lord.
Close it.
Take a
ಏನ್
chance.
ಮಾಡಕ್ಕೆ?
There's some
ಏನಿದ್ರು
other-
ಅಷ್ಟೇನೆ.
ಇನ್ನೊಂದು matter pending is a slight different matter.
From
There's no judgment passed, my lord. He's
The
been-
petitioner is before this court, seeking the following prayer. The prayer that is sought at the hands of this court is completely answered by the judgments rendered by this court in so and so. Illeredu hakpidi. The learned counsel for the petitioner seeks 2 weeks time, 10 days time. List the matter on 4th December in fresh matters list.
But afterwards.
No, sir. This you can't do. Shivraj, this is not correct. When the judgments are against you, you should not do
No,
that.
no, Lordship may dispose.
There.
I'm just asking my lord that
ಏನು ಬೇರೆ ಬೆಂಚ್ ಮುಂದೆ ಬೇರೆ ಮಾಡ್ಬೋದು ಅಂತನಾ?
your lordship has taken away, but otherwise my lord I
So I should
justify.
recuse, is it?
No, no, I'm not
Mata?
saying- I'm not- Lordship may pass orders right
What
now.
is this submission?
No, no, no.
Anyway, yes.
Tavu, pass.
This is not correct. You know, you will convince me andre ಬೇರೆ ಮಾತು.
But squarely covered, my lord.
You should be graceful, sir. What is all this? With your experience, you should not do all this.
Please.
We'll dispose it. Yes. ಆದ್ರೂ ಏನಾದ್ರು ಲೀವೇ ಇದ್ರೆ ಕೊಡಕ್ ಒಂದು ಕೊಡ್ತೀವಿ. Yes.
Bill number 2, Shreya is Katkipat.
Respondent number 2.
Split up memo.
Breakup memo ಕೊಡಿ. ಕಾಯ್ಕೊಂಡ್ರೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅವ್ರು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Copy ಕೊಟ್ಟಿದ್ದಾರೆ my lord. They wanted to realize certain exhibits which they are not furnished. ಕೊಟ್ರೆ we can think of it.
ಕೊಡಿ.
Please.
Where are those exhibits?
Yes.
One minute.
ಅವ್ರಿಗೆ ಕೊಡಿ. ಅವ್ರು ಕೊಟ್ಟಿ ನಾಳೆ ತಗೊಳ್ಳ ಸೋಮವಾರ ತಗೊಳ್ಳ
ಸೋಮವಾರ
ಮಂಡೇ ಲಿಸ್ಟ್ ಆನ್ ಮಂಡೇ ಇನ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್.
Bill number 3, Sunanda P. Patil, Prashant Matpati.
My compromise was, my lord, challenged.
And for the petitioner in
The
this case, my
grandmother,
lord,
my lord, 12 lakh claim.
challenged the award.
ಗೊತ್ತಾಯ್ತು. I heard you twice.
Lord, my submission is that, my lord, a 12 lakh was, my lord, awarded by the trial court. In view of the interim order, my lord, I'm not able to get, my lord, signed on the merit, my lord. Complaint, my lord, on for a moment, page 30. 30, my lord. Lord,
ಯಾರ್ ಕಂಪ್ಲೇಂಟ್ ಇದು?
complainant is the son of the petitioner. Not the 5th line in the, my lords, I may permit it to, then I'll locus my in respect of petitioner. ನಾ ಅನಿತಾ ಭೈರು ಪ್ರಕಾರ 3 ಜನ ಮಕ್ಕಳಿದ್ದು ನನ್ನ ತಂಗಿ ಅನಿತಾ ಇವಳಿಗೆ ಹುಕ್ಕೇರಿ ತಾಲೂಕಿನ ಶಿವಪುರ್ ಗ್ರಾಮದ ಬಾಲಕೃಷ್ಣ ರಾಮ್ ಕರಾಡೆ ಇವನು ಜೊತೆಗೆ ಮದುವೆ ಮಾಡಿದ್ದು ಅವಳಿಗೆ ಗೋಕುಳ 9 ವರ್ಷ ಎಂಬುವ ಹೆಣ್ಣು ಮಗಳು ಇರುತ್ತಾಳೆ. ನನ್ನ ಅತ್ತೆ ವಿಟಾಬಾಯಿ ಅನ್ನಪ್ಪ ಶಿಂದೆ ಇವರಿಗೆ ಗಂಡು ಮಕ್ಕಳು ಇಲ್ಲದಿದ್ದರಿಂದ ನನ್ನ ತಮ್ಮ ಭೈರು ಇವನು ದತ್ತಕ ತೆಗೆದುಕೊಂಡಿದ್ದು ನನ್ನ ತಮ್ಮ ಭೈರು ಅಪ್ಪಣ್ಣ ಶಿಂದೆ ಇವನು ಹೆಂಡತಿ ರೇಖಾ ಇವಳಿಗೆ ರಶಿಕಾ ವಯಸ್ಸು 5 ಹೂ ಇಸ್ ದಿ ಗ್ರ್ಯಾಂಡ್ ಡಾಟರ್ ಹೆಣ್ಣು ಮಗಳು ಇದ್ದು ರೇಖಾ ಇವಳು ಈಗ ಸುಮಾರು 2 ವರ್ಷಗಳಿಂದ ಹಿಂದೆ ನನ್ನ ತಮ್ಮ ಭೈರು ಇವನಿಗೆ ಡೈವರ್ಸ್ ಕೊಟ್ಟು ಅವನ ಮಗಳಿಗೆ ಕರೆದುಕೊಂಡು ಅವಳ ತವರು ಮನೆ ಮನಗುತ್ತಿಗೆ ಹೋಗಿರ್ತಾಳೆ. ಮೈ ಲಾರ್ಡ್, he was adopted a long back, my lord. He is not the even mother also, my lord.
Yes. Heard reserved.
One submission, my lord.
Yes.
Only my submission before this honorable court is not, it is not for the benefit of the minor child, because she is entitled for more than 12 lakh rupees. Even then they have compromised for rupees 12 lakh. That is my reason. And till the.
You will not get a rupee, I told you last time.
Pardon, my lord.
Any enhancement will only be for the benefit of the family,
That-
not
that
1
is-
rupee you will get.
Only that the child will get. I will not say anything.
Nor you will be a guardian for that.
And I have
Maybe, but my submission before this honorable
ಅಲ್ಲ,
court is.
ಕೊರ್ಸ್ಟಿಂದ you have stopped compensation to go to the child.
That is my intention also, my lord.
That is
I'm-
your intention.
Please,
We'll take care
your
of the
lordship.
intention. Yes.
Heard
Reserved.
only.
Yes, next.
and my lords, I have been appointed by the trial court, my lords, with application.
Yes.
Page 70. Please, much.
May it please your lordship. The cross subsidy surcharge, my lord, is under challenge.
Why is it come in fresh matters?
Sorry, my lord.
Why is it
No,
come in-
because your lordship said it will, my lord, lordships will dispose of this matter. It has come up, there is some financial implication. Also, my lord, I am requesting that the matter.
Preliminary hearing ಅಂತ ಇದೆ. Fresh matters ಗೆ ಹಾಕ್ತೀವಿ.
All right.
Hey.
Yes, great. The issue is this, my lord. The cross subsidy surcharge is under challenge. The electricity Act. The cross subsidy surcharge, my lord, traces itself to the Electricity Act, which, my lord, is a tariff levied under section 42. May I persuade your lordships to see, my lord? Enjoy. The
Synopsis ಹಾಕಿದ್ದೀರಾ?
section, yes, it is. I'm sorry, my lord, we have.
ಹಾಕಿದ್ದೀರಾ?
ನನ್ನ ಹತ್ರ
Citations ಇದೆ. ಬರೀ citations ಇದೆ. ಅದು
ಅಲ್ಲ,
ನಾವು
ನಂದು ಬರೀ 10 ನಿಮಿಷ, ನಾನು 15 ನಿಮಿಷ ಅಷ್ಟೇ ಸರ್. 10 ನಿಮಿಷ. I'll not argue much. I'll state the propositions and, my lord, lordships will see, my lord, the section 42 says that every distribution licensee can collect the cross subsidy surcharge. May I persuade your lordships to see, my lord, section 42(4). The section 42 begins by saying that it shall be the duty of distribution licensee to develop, maintain efficient, coordinated, so and so, so and so. Then, my lord, 4, where the state commission permits a consumer or class of consumers to receive supply of electricity from a person other than distribution licensee of his area, such consumer shall be liable to pay an additional surcharge on the charges of billing as may be specified. Now, my lord, this is one source which is called, my lord, the additional surcharge. And prior to that, my lord, your lordships will see 3 also for a moment, where any person whose premises are situated in the area of supply, so and so, so and so, such distribution licensee by notice required. All that, my lord, is one. So basically, my lord, the cross subsidy surcharge is a charge on wheeling, where the consumer avails power. Suppose he is HESCOM, my lord, my learned friend's client, he is bypassed and I take power from some other source being in the his area of supply, then, my lord, I pay to the distribution licensee. Similar provisions exist under the Electricity Act, under, my lord, section 37, your lordship, 39 also. Your lordships will see 39 for a moment. Your lordships will see, my lord, ಇಲ್ಲಿ 39 ನಲ್ಲಿ D2D, my lord, to provide
37 ಅಲ್ಲಲ್ಲ?
No, sorry, 39, I'm sorry. To provide non-discriminatory open access to its transmission system for use of any licensee, any consumer, or open access. This will any consumer, as and when such open access is provided by the State Commission under subsection 2 of section 42 on payment of transmission charge on the surcharge thereon as may be specified by the State Commission. So, my lord, on the transmission charges, suppose I am availing open access from KPTCL, a transmission licensee, then I pay on the transmission charge that I am paying. If I avail open access from distribution licensee, then I pay on the wheeling charge. Transmission and wheeling are, my lord, distinct, because wheeling means from a distribution licensee, which is, my lord, defined term under 276. Subsection 76.
Now, what is the controversy?
Yes, the controversy is this, my lord. The KERC passes a tariff order in 2014, 15, 16 on various dates, and that cross subsidy surcharge is determined under that act, under the tariff orders, my lord. And much later, in 2018-19, the demands are raised. And, my lord, I approach this honorable court challenging those tariff orders. And this honorable court says, my lord, all these matters require a detailed consideration, relegates me back to the commission to pass a detailed order on all contentions being kept open. And commission passes an order at Annexure B, and which, my lord, the objections that I had filed are the same objections that I have raised here also, because they are not answered in the tariff, in the order passed by the KERC. First objection is, my lord, that the licensees, the so-called respondents before your lordships are not distribution licensees, they are mere supply companies, and only the distribution licensees are entitled to collect the surcharge, because section 42 or, my lord, section 39 or 37 entitles only the licensees to collect the surcharge is the first contention, my lord. Second contention is that, my lord, the the open access is availed from KPTCL. I am, my lord, a cogeneration plant which is producing power at 110 kV, 120 kV, 220 kV, etc. So I draw the power at those voltages which belong to KPTCL and not to distribution licensees. So therefore, my lord, under section 39, which I read before your lordships, KPTCL can ask me, because I have availed open access from him, not from these distribution companies. Third is, my lord, that I am not a consumer at all. I am a generating company who generates power, and power is coming to me. Maybe I source power from IEX, Indian Energy Exchange, which is not purchased, which is I myself avail it. There is no, my lord, agent attorney relationship. Then, my lord, the other one is that the tariff orders passed by KERC as well as this order says solar power project in the yar power togotare avರಿಗೆ cross subsidy illa anta. So I am saying it is hostile discrimination. And my lord, the Electricity Act makes no distinction between the source of power. It only says the wire nal hogide ivrige iಷ್ಟು loss agide ಕೊಟ್ಬಿಡಿ ಅಂತ. So it is revenue neutral proposition. It is not dependent on consumers. So, and then, my lord, the tariff orders were already passed by the commission, which were altered from time to time.
You are drawing from solar sources.
No, my lord, I am from cogeneration source. So what I am saying is, solar navrige iವರು total exemption ಕೊಡ್ತಾರೆ, ನನಗೆ ಮಾತ್ರ subsidy ತಗೊಳ್ತಾರೆ. These are all, my lord, without prejudice to one another. Then, my lord, the tariff, the charges that are determined have to be published as per section 27(9) of the Karnataka Electricity Reforms Act, which is not done, is, my lord, the next contention. Then, my lord, the tariff orders are altered. Illi enagittu, the tariff order had fixed that all entities will pay this cross subsidy surcharge until 2014 al hakidru. Very next year, Lord, solar is exempted within a financial year. So, my lord, there is an embargo under the Electricity Act to alter the tariff within one financial year. So therefore, my lord, on that count also it is wrong. So, my lord, the first proposition I am stating before your lordships is that, my lord, they don't have a license. They are only supply companies. Just, my lord, HESCOM is a Hubli supply company, not a distribution licensee. There was a license granted, my lord, in the past, which was valid till 2008. And after that, your lordships will see, no license has ever been applied for nor granted. On the count, there are two grounds, my lord, on which the KERC admits that license kottilla anta avaru ಒಪ್ಕೋತಾರೆ. Renewal agilla anta avaru ಒಪ್ಕೋತಾರೆ. On two counts, my lord, they say they are not required. One, they say under section 14, your lordships will see that certain entities are exempt, and one of the proviso to section 14 says that state government, when it engages in distribution of power or transmission, they are not required to take. So the commission equates the supply companies and distribution companies to that of a state. So therefore, my lord, this is one major, my lord, premise on which they say license is not required. And my contention to that is, my lord, companies are different, state government is different. Because the shareholding, they own the shares, they don't become a distribution companies don't become state. And the exemption under the proviso to section 14 does not apply to the distribution companies. Now, my lord, this is the major premise.
Bottom line ಹೇಳ್ಬಿಡಿ, ಪ್ರಾಬ್ಲಮ್ ಏನು?
ಅವರಿಗೆ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಒಂದು.
ನಿಮಗೆ ಏನು ತೊಂದರೆ ಕೊಟ್ಟಿದ್ದಾರೆ?
ನಮಗೆ annexure C, the lordships will see, lord, that demand is raised.
ಅಷ್ಟೇ ಅಲ್ಲ, demand is raised notwithstanding the fact that you are a cogen. Yes. And the discrimination is they are giving
hostile discrimination.
Hostile discrimination.
Yes. And you are, I am saying, Lord, this cross subsidy could have been levied.
Demand is challenged.
Yes, demand is challenged. Also the order, my lord, annexure A.
What order is
the KERC order, which my lord authorizes them to collect. Andre ee demand galu sari ide anta.
ಹೌದು, ವಾಪಸ್ ಕಳಿಸಿದ್ಮೇಲೆ KERC has not considered anything.
Yes, none of these contentions are considered, my lord. My respectful submission is lordships may see the reasoning and the, my lord, issues framed are very bald. And, my lord, the KERC's order, my lord, I am. Yes, may I persuade your lordships to see 100915, my lord, Hiranyakeshi. 100915, or whichever your lordships are holding.
I am holding 104538.
That, lord. No, I'm sorry, my lord.
ಅದೇ ಕೊಡಿ, ನೀವು ನಿಮ್ಮ ಹತ್ರ ಯಾವುದು ಇದೆ?
Yes, yes, my lord. We have 915, the 850, my lord. My apologies. 850, my lord.
Ilva?
I will, my lord, attune myself.
Your grounds are discrimination.
Yes, yes. One is, my lord, license.
Non-application of mind.
Yes. The license, my lord, is also the core because the entire order devotes itself to that issue. Your lordships will see, my lord, section 42 for a moment. It clearly says that, my lord, section
100850.
Yes, my lord, which is Hiranyakeshi. Yes.
Whatever.
In this, your lordships will see the issues framed at, my lord,
page.
Yes, my lord. Page 180, my lord.
By the KERC?
Yes. in this order. One is, my lord, the petitioner holds a valid license. It's the first issue.
That's held in your favor?
No, my lord. It is held against me. And then petitioner is discriminated for not granting so and so to solar projects, held against me. Then are liable to pay cross subsidy, if so, under which category, is held against me. Then demand letters issued by so and so, my lord, consequently are
Obviously held against you.
So first reasoning, your lordships will see at page 181, my lord, that they quote the order of Sesa Sterlite, which my learned friend also has produced, my lord. This, my lord, is the complete answer to the licensing issue. And, my lord, my first contention is that, my lord, the Sesa Sterlite judgment has not been properly appreciated. May I, my lord, persuade your lordships to see the compilation given by my learned friend. I'll not trouble, my lord. He has given exhaustively all the cases that I also wish to rely upon. My lord, compilation, my lord, which my learned friend has produced. Have you?
File a common compilation for all the cases.
Yes, in which, my lord, lordships will see this very issue fell for consideration and, my lord, answered in my favor. The lordships will see, my lord, the Sesa Sterlite judgment, which your lordships will find. My lord, this was a case where a SEZ developer had applied, my lord, said that I don't have to pay cross subsidy surcharge because I am myself a licensee. And therefore, my lord, that the cross subsidy was said to be not applicable. But then your lordships will see, my lord, the answer given. Your lordships will see, my lord, the exact answer. Sorry, my lord. 44.2. Your lordships will see from 44.1 onwards, my lord. There has to be a harmonious construction of SEZ Act and the Electricity Act to give effect to the provisions of both acts, so long as they are not inconsistent, etc., etc. Then your lordships will see 44.2. The appellate tribunal pointed out that there are 9 provisos to section 14B of the Electricity Act, and another is added in respect of the notification so and so, which is, my lord, the SEZ provision. A reading of these provisions would indicate that some of them confer the status of deemed distribution license on certain specified entities who are not required to take a separate license from the state commission under this act, whereas some other provisos merely declare the party as deemed licensee and nothing specified as to whether they are required to obtain the license or not. However, when it comes to the proviso 4, 8 and 2, that Damodar Corporation, state government are not required to obtain license, and other provisos do not confer such privilege, which would be required to obtain license. Now, my lord, what the Honorable Supreme Court says is, my lord, the section 14 interpretation. May I persuade your lordships to see, my lord, section 14. This is interpreted. First proviso, the section begins, my lord, section 14 begins by saying appropriate commission may on an application so and so grant license for transmission, distribution, so and for trading. Provided that, the first proviso reads, my lord, the first proviso says, provided that person engaged in the business of transmission or supply of electricity under the provisions of repealed laws or any other act specified in the schedule on or before the appointed date shall be deemed to be a licensee under this act for such period as may be stipulated in the license clearance approval granted by him, granted to him under the repealed laws or such act specified in the schedule. I hold here, my lord. Reforms Act nalli ivrige license kottiddu. 2000 So then, my lord, Electricity Act was not in vogue. It is a scheduled act. It is not repealed. To the extent the provisions are not inconsistent, Electricity Act, my lord, the repealed act, the Reforms Act prevails, and for all other things, Electricity Act prevails. So ESCOMs took license under the Reforms Act. So the first proviso to the act says, the Electricity Act 14 says, my lord, that ನೀವು ಅದರಲ್ಲಿ ತಗೊಂಡಿದ್ದಿದ್ರೆ your license will be in vogue for the period specified in those acts, or I'm reading further, or such acts specified in the schedule and provisions of the repealed act, or act specified in the schedule in respect of such license shall apply for a period of 1 year from the date of commencement of this act, or such earlier period as may be specified at the request of licensee, so and so. So, my lord, my first contention, this is what is, my lord, interpreted. I am reading further, my lord, provided further that central transmission utility or state transmission utility shall be deemed to be a transmission licensee under this act. Then, my lord, provided that in case of government transmit, your lordships will see, provided also that in case of appropriate government transmits electricity or distribution or undertakes trading, whether or before commencement, the government shall be deemed to be a licensee under this act, but shall not be required to obtain the license. This is, my lord, the reasoning given to say that, my lord, the KPT, the ESCOMs do not require a license. What the Honorable Supreme Court says, and also, my lord, what my learned friend relies upon, and what the impugned order says, our government to ESCOM say government to. Now I am relying upon a judgment which is, my lord, a very well settled proposition. Shareholder is not same as the company. So therefore, my lord, the Honorable Justice Chandrachud, my lord, the senior Honorable Justice Chandrachud says government owns the shares, not the assets of the company nor the license. So therefore, my lord, merely because you have you are a government held company, you are not exempt. Then your lordships will see Damodar Valley Corporation also is not required to obtain license, my lord, which is what the Honorable Supreme Court says in that judgment. Also, my lord, government company under 131 of the so-and-so are created pursuant to the act shall not be. So, my lord, what the act says is, if you are created under this act, the Electricity Act, then you are exempt. But if you are created under an old act, then you still have to obtain a license. Now, your lordships may, my lord, permit me to revisit, my lord, the 44.2 in, my lord, the Cesar Sterlite judgment. I am rereading it for my benefit, my lord. Lordships have, my lord. A reading of these provisions would indicate that some of them confer the status of deemed distribution licensees on some specified entities who are not required for a separate license, required to take a separate license from the State Commission under the Act, whereas some other provisos merely declare party as deemed licensee and nothing is specified as to whether they are required to obtain a license or not. However, when it is specifically provided in proviso 4, 8 and 2 that Damodar Valley Corporation and state government are not required to obtain license, the said provisions do not confer such privilege. They would be required to obtain license. This is, my lord, the heart of the issue. And then, your lordship, on that count, my lord, the licensee or the company which had applied, the Cesar Sterlite, was asked to take the license. Now, my lord, we'll see the reasoning given by the commission on this proposition at, my lord, yes, at, my lord, the page 202, Lord, is the almost idella heli. Your lordships will see, my lord, page 203. The commission in the case of Kare Power, they quote some other order and say, discharge the exemption of cross subsidy and other charges granted to consumer sourcing from so and so. The decision.
You read paragraph 44 point?
Yes, 44 point in Cesar Sterlite, my lord, 44.2.
You rely on that?
Yes, my lord. That's my entire case, my lord.
But the conclusion is at 46.
Yes, my lord.
Read 46.
Yes, my lord. We are in agreement.
Last 3 lines of 46.
Yes, my lord. Was issued keeping in view the concept of multi SEZs and will apply only to such cases. The said notification will not apply to developer like appellant who has established SEZ for himself. Sorry, my lord. Sorry. Having regard to the aforesaid factual and legal aspects, keeping in mind the for which the CSS is payable, in explained in detail in the earlier part of the judgment, we are of the opinion that facts of this case, it is not possible for the appellant to avoid payment of. Correct. Why? Correct. That's what I am also saying, Lord. ಅದರಲ್ಲಿ ಇವರು ನಾನೇ ಲೈಸೆನ್ಸಿ ಅಂತ ಕುತ್ಕೊಂಡಿದ್ರು. This SEZ, the distinction is this. This Cesar Sterlite said, I am myself a licensee. Why should I pay you? You are also a licensee. I am also a licensee. They said, no, you are not a licensee. You are a deemed licensee.
You have established the SEZ yourself.
So therefore, my lord, by virtue of your establishment, you don't become. You have to obtain license. Then you get that status of distribution licensee. Then you can evade the cross subsidy. So I am also saying the same thing to my learned friends' clients.
Same thing you have to give exemption for Allah.
ಅಲ್ಲಲ್ಲ ಇವ್ರ ಲೈಸೆನ್ಸ್ ಅಲ್ಲಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಇವ್ರೇನ್ ಹೇಳ್ತಾರೆ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ವಿಲ್ ಸಿ ನೀವು ನಮ್ಮ ಏರಿಯಾದಲ್ಲಿ ಇದೀರಿ ನನಗೆ ಲೈಸೆನ್ಸ್ ನನಗೆ ಕ್ರಾಸ್ ಸಬ್ಸಿಡಿ ಕಟ್ಟಿ ಅಂತ ಇವ್ರು ಕೇಳೋದು. I am not, no, Lord, the proposition is not that I want to take a license and do. I am saying you are not a licensee to ask me this. You are merely a supply company. You don't have a license. Your license is not renewed. So you can't ask me. I am not saying because I am a licensee, I am exempt. No, my lord. So this, my lord, is the heart of the matter. I am reading once again, my lord, the reasoning given on the judgment is, my lord, quoted in extensio. And they say, your lordships will see how, my lord, the KERC reasons this. Sorry, my lord, I am in the reasoning given by the KERC, my lord. It begins at 180. 181.
Yes.
181.
Oh, 181.
And 43 is quoted. Then your lordships will see R.D. Shetty is quoted. Then finally, my lord, the reasoning seems to be that he is the state. It is not, my lord, the lordships will see, after all this is quoted, in this background, lordships will see 192. See the flawed reasoning, my lord. In this background, 192, my lord. In the background, respondent ESCOMs are registered companies having a board of directors appointed by the government. 100% equity is held by the state government. ESCOMs are distributing power supply, so and so. State government is providing considerable amount of subsidy. In view of the above, read with the decisions of the Honorable Supreme Court mentioned supra, Commission is of the view that respondent ESCOMs are instrumentality of the state government and hence Article 12. No, my respectful submission is, my lord, you have to be an appropriate government, not an instrumentality. Then, my lord, even Century Club, my lord, can claim exemption.
Century Club is not instrumentality, sir.
Allah, the Article
Don't
12 on
stretch it so much.
public, sorry. That
Century
public,
Club. Century Club in no century is Article 12.
So, ಅಲ್ಲ ಈ ತರದ್ದೆಲ್ಲ ರೀಸನಿಂಗ್ ಹೇಳೋದು.
ಅಲ್ಲ ಅದು ನೀವು ಆ
I'm
ತರ
sorry.
ರೀಸನಿಂಗ್ ಅವರೇನೋ ಕೊಟ್ಟಿದ್ದಾರೆ. ನೀವು illustration ಕೊಟ್ಟಿದ್ದು.
I'm sorry. I take back that one.
Yes,
Now, if this logic is applied, your lordships may see, my lord, the judgment that I have relied upon, chairman of the very clearly, my lord, establishes.
So ESCOMs are a state under Article 12.
State, yes,
No doubt,
but not
no doubt.
appropriate government.
No doubt about it.
Yes, your lordships will see, my lord, this is what was argued in a number of cases, my lord, to exempt them from tax payment. And therefore, my lord, it came, this was answered by one of the, my lord, celebrated cases, Western Coalfields, which is in my compilation, my lord, page 96.
That is tax exemption.
ಅದರಲ್ಲಿ ಅವ್ರು ಹೇಳ್ತಾರೆ.
Exemption is not
No, my lord.
the same as your cross subsidy.
Yes, I will, no, my lord.
Cross surcharge.
I will restate my proposition.
Yes.
The reasoning given by the commission is that they are held, complete 100% held company of the state government. So therefore they are a state government. This is
That
flawed.
is the reason.
That's the reason.
According to you, that is wrong.
That is flawed. Your lordships
No,
will.
according to you, that is flawed.
Yes.
It should be an appropriate government or the government itself. Only then
Yes,
they can
yes,
exercise that.
yes,
That will answer.
Exactly. That your lordships will see.
Yes.
The appropriate government is also a defined term under the Electricity Act.
Yes.
Your lordships will see, my lord, appropriate government, which, my lord, is defined term, which, my lord, is defined to mean appropriate government, my lord, is the state government or central government. There's no, lordships will see, my lord, I'm sorry.
Yes, sir.
4, section 4 in the dictionary clause, my lord, section 2. Appropriate commission, sorry, 5, sorry. The central government, appropriate government means central government in respect of generating company wholly or only part by it. Then in respect of interstate so and so, then NLDC. In any other case, state government having jurisdiction under this act. Is the government itself not an instrumentality of the government or a shareholder, a company under which the my lord, government is a shareholder. Therefore, my lord, in Western Coalfields, the same logic, and even in APSRTC's case, Honorable Justice my lord Chandrachud holds that just because your lordships will see page 108 of my compilation, my lord, in Western Coalfields, the decision of this court in APSRTC puts the matter beyond all doubt.
APSRTC.
Yes, ಆ ಕೇಸ್ನಲ್ಲಿ ಅವರು ಹೇಳೋದು that Western Coalfields judgment ನಲ್ಲಿ 108 of my compilation, my lord.
108.
Yes, my lord. Western Coalfields versus Special Area Authority. And
That's
lordships get it.
108. Yes, sir.
Lordships please. This was the very contention taken. The decision of this court in APSRTC puts the matter beyond all doubt. In the case of Andhra Pradesh Transport Corporation, claimed exemption from taxation under 289, by which the property and income of a state is exempt from union taxation. This court, while rejecting corporation's claim, held that though it was wholly controlled by the state government, it had a separate entity and its income was not the income of the state government. Gajendra Kadkar, CJ, while speaking for the court, referred to the judgments of Lord Denning in so-and-so case, which the learned so-and-so. In the eye of law, corporation in its own master is its own master and is answerable to fully all its persons and corporations. It is not the crown and has none immunities or privileges of the crown. Its servants are not civil servants and its property is not crown property. Now, my lord, they rely upon this and hold that state, your lordships will see in Pennington's company, so and so, it is stated that there are 2 dedicated cases for which the court was disregarded in separate legal entity of a company and was done because the company was formed or used to facilitate evasion of legal obligations. The learned author, after referring to the English and American decisions, has summed up the position of the words of so and so to the effect that as a general rule, corporation will be looked upon as a legal entity and an exception can be made when notion of legal entity is used to defeat public convenience, so and so, that your lordships may, my lord, ignore. So finally, my lord,
So according to you, these ESCOMs are not
state government. State howdu, writ lies. They may be under the Right to Information Act, my lord, that also may happen. They are not state government or the appropriate government, which, my lord, is exclusively a different entity. And kindly see, my lord, the reasoning at 192. I am rereading this for my benefit.
Yes, please.
And lordships will see ESCOMs are registered companies under Companies Act, have a board of directors. This, my lord, juxtaposed with this decision of the Western Coalfields, proves my point beyond doubt. That, my lord, ESCOMs are distributing supply of which backbone of the economy. Andre, suppose, my lord, tomorrow one private entity also supplies power, and so government holds maybe some 50% in it, which is the case in Mumbai, BSES and, my lord, Tata. Also, the government shares are held. So, if this logic is, my lord, accepted, and secondly, my lord, if they are state government, they are paying tax. Nale idinna helbitre, ಅಲ್ಲಿ ಟ್ಯಾಕ್ಸು ಕಟ್ಟಂಗಿಲ್ಲ, ಇನ್ನೊಂದು ಇಲ್ಲ. They are paying GST, they are paying tax, they are paying surcharge. So therefore, my lord, my submission is that the reasoning is completely flawed. Then your lordships will see the other reasoning given is that under Annexure A, Regulation 3, ಇದು ನಾವೊಂದು ರೆಗ್ಯುಲೇಷನ್ ಮಾಡಿದೀವಿ. ಆ ರೆಗ್ಯುಲೇಷನ್ ನಲ್ಲಿ ನಾವು ಹೇಳಿದೀವಿ ಇವರಿಗೆ ಎಕ್ಸೆಂಪ್ಷನ್ ಇದೆ ಅಂತ ಹೇಳಿ. Therefore they are exempt. That is, my lord, the second ground, which also I have challenged. Your lordships will see 3, Regulation 3 at page 85 of my writ petition, my lord.
Yes, sir.
Any person who is deemed to be a licensee, lordships get it, my lord, who is 3(1) nalli, any person who is deemed to be a licensee under so and so shall not be required to apply and obtain a license under this act, however conditions of license specified in so and so. So I am challenging this for this reason, my lord, that the licensing, the regulation, these are regulations framed under the act. When the act clearly says that the deemed licensees have to take a license, and if you are a deemed licensee operated as a state government and as some Damodar Valley Corporation or 1 or 2 entities such as this, all others have to take. This is, my lord, the dictum of the Honorable Supreme Court in Sesa Sterlite. Sesa Sterlite judgment, my lord, is good law even to this date. There are SEZs which, my lord, if this is held in their favor, that you don't require a license, then no SEZ will, then SEZ will say, I'm also a deemed licensee. Then why are you compelling? I am also like these distribution companies. So therefore, my lord, what the Honorable Supreme Court tried to, the malady that the Honorable Supreme Court tried to remedy in Sesa Sterlite will be, my lord, paled into oblivion. So on this count, my lord, I am saying that the license is a sine qua non for collection. Your lordships will see, my lord, section 42. Who is entitled to collect the cross subsidy surcharge? It is only the licensee and none else. Your lordships, it is not, my lord, the supply company. Merely because I am in their jurisdiction, they don't become entitled. The lordships will see duties. Section 42, my lord, starts. Duties of the distribution licensees. It shall be the duty of the distribution licensee to develop so and so, so and so. Then your lordships will see 42(4), where the state commission permits a consumer. This is, my lord, the charging.
42.
4, my lord, not
4. Yeah, 4, yes.
Yes, 4. Where the commission permits a consumer or so and so to from a person other than distribution licensee, such consumer shall be liable to pay additional surcharge on charges of wheeling as may be specified to meet the cost of so and so. And Lord, this, in my respectful submission, is a privilege enjoyed by the distribution licensee and not a company of this kind. And the second, my lord, proposition that I stated is the fact that who can collect this? Now your lordships will see the demands raised by the distribution companies at Annexure C, my lord, which your lordships will get.
According to you, it can be collected by?
Howdo, without prejudice to this, your lordships will, lord, now see the demand at Annexure C at page 213. Your lordships will see, my lord, the demands raised. One demand, the 213 nalli Annexure C is the demand raised. Your lordships will see the period for which it is levied, 2013 onwards. In 2017, barred by limitation, my lord, is another ground, is one. Secondly, your lordships will see, HESCOM has raised this demand on me, Managing Director Hiranyakeshi. So my respectful submission is, who are all entitled, now presume against me, my lord, that he is a distribution licensee and he is entitled to collect the charge. But whether HESCOM can collect the charges, my lord, is the other issue.
That's because it is not the government.
Adalla. Yurige, there is also KPTCL, who is a transmission licensee, who can collect the transmission charges under section 35, my lord. Your lordships will see 39, sorry.
Yes, yes.
39, which I read in the first lord phase. This surcharge can be collected. The surcharge depends on whose network are you connected with. It is undisputed, my lord.
You said the limitation ಏನು ಬರುತ್ತೆ?
Limitation ಇದರಲ್ಲಿ lordships will see, my lord, 2013 ನಿಂದ collect ಮಾಡ್ತಾರೆ.
2013 ಇಂದ collect ಮಾಡಿದ್ರ?
Yes, my lord.
ಎಲ್ಲಿವರೆಗೆ?
2016 ವರೆಗೂ. The period is, my lord, 1713 to 110/2006. 16, sorry. I'm sorry, 31/10/2016, my lord.
And the demand is raised in 2017.
Yes, my lord.
Why did you take 5 years to file the writ petition?
Illa, I filed it, my lord. Initial round I challenged it. Then, my lord, I was relegated back. Your lordships will recall. Amel is second round. And your lordships will see, these demands also don't say anything. Now, your lordships will see, idralli euro metered consumption. See the demands, my lord, how they are raised. Units computed for so and so, cross subsidy surcharge, 296, 476. This is, my lord, another, this takes me to the third ground, my lord, that the cross subsidy surcharge can be levied from a consumer. If I should be your consumer, I am not. I, my lord, am sourcing power under open access from some source, under transmission network at 110 kV level and above. I don't have an RR number, revenue register number. I don't have any contractual privity with you. So therefore, my lord, I am not causing, now the whole rationale is, my lord, if you are not in that distribution area, if you are in that distribution area, you take power from others, you are causing loss to me. Because, my lord, ನನ್ನ ಕನ್ಸ್ಯೂಮರ್ ಆಗಿ ನಾನ್ ಟ್ರಾನ್ಸ್ಮಿಷನ್ ನೆಟ್ವರ್ಕ್ ನಿಮ್ಗೋಸ್ಕರ ಹಾಕಿ ನೀವು ಬೇರೆಯವ್ರ ಹತ್ರ ತಗೋತೀರಿ ಅಂತ ಆದ್ರೆ, ಆನ್ ಲೈಟರ್ ನೋಟ್, my lord, ಹೋಟ್ಲಲ್ಲಿ ಊಟ ಮಾಡಿದ್ರು ನಾವು ಇವ್ರಿಗೆ ದುಡ್ಡು ಕೊಡ್ಬೇಕು. ನೀವ್ ಯಾಕೆ ಊಟ ಮಾಡಿದ್ರಿ? ಸೊ ಇಫ್ ಐ therefore, my lord, the transmission charge,
ಅವ್ರ ಮನೆ ಇರ್ಬೇಕಾದ್ರೆ ಹೋಟೆಲ್ಗೆ ಯಾಕೆ
ಹೋಗ್ತೀರಾ ಅಂತ. That is what, my lord, is the whole logic. ESCOM is your home and lordships will see who all can collect. The state transmission utility can also collect. Page section 39 says, my lord, KPTCL can collect when your network is bypassed and I take it from somebody else. So, my lord, what effectively is happening is, yes, I am bypassing the transmission network of KPTCL. He cannot charge, he is charging, he should have charged the cross subsidy if at all. But ESCOMs are charging, my lord, under section 42 supposedly. So everywhere, my lord, whichever network is used is the criterion, is the anvil on which, my lord, the cross subsidy has to be tested. And then your lordships will see how a consumer andre enu anta. You should have an RR number, my lord. You should have a category that is not there. There is no category. Your lordships will see the bill. Naan yav category ge bartini. Why this becomes crucial is because, my lord, in the tariff order, the cross subsidy depends on your category of consumer. Your HT2A, 2B, LTO, LT, whatever. But I am not categorized at all for this simple reason that I am not your customer at all, consumer at all. So therefore, my lord, the ground was that how could you ask me to pay the cross subsidy surcharge when you have not categorized me at all? Now, this aspect is not answered in entirety, subject to correction by my learned friend, my lord. This yaake anteli iವರು ಹೇಳೋದಿಲ್ಲ. Then again, your lordships will see section 42 again, which says whoever is connected, you bypass the network and source the power from other sources, you have to pay. It doesn't make a distinction between solar, cogen, whatever, my lord. So to make an artificial distinction between the various sources is again, my lord, hostile discrimination and ultra vires the Electricity Act. This aspect is answered, my lord, feebly in the order by saying, nodi iga tariff ಒಬ್ಬೊಬ್ಬರಿಗೆ ಒಂದೊಂದು tariff ಹಾಕಲ್ವಾ, ನಾವು solar ಗೆ ಒಂದು ಹಾಕ್ತೀವಿ, ನಿಮಗೆ ಒಂದು ಹಾಕ್ತೀವಿ, ಹಂಗ ಹಾಕಿದೀವಿ ಅಂತ. The honorable high court in Kare Power's judgment, which my learned friend has quoted, also has said that they have a right to distinguish between various consumer categories and put it. But my submission is, my lord, that if so, then why this rate to me and zero to him is not explained? Iga
0 to him is solar.
Sorry, my lord.
0 to him is solar.
0 to, yes, my lord. 0 to solar. 0 to solar. And this 4 rupees, 7 rupees, whatever your lordship saw. Now, my lord, I am ready to presume against me that my cost of production is more or less. ನನ್ನ ಟ್ಯಾರಿಫ್ ಎಷ್ಟು, ನಾನು ನಿಮಗೆ ಸೇಲ್ ಮಾಡೋದಾದ್ರೆ ನನಗೆ ಎಷ್ಟು ಟ್ಯಾರಿಫ್ ತಗೋತಾರೋ ಅದೇ ರೇಟೇ ಸೋಲಾರ್ಗೂ ತಗೋತಾರೆ. Lordships may, my lord, record my submission that 5 rupees, 7 rupees, whatever they are saying, that is my tariff also. Then it was 4 rupees 68 paise, whatever. Now solar also got 5 rupees 60 paise. How could that be so drastic? Now, is it that solar gets 100 rupees and I get 1? No, it is not so, my lord. But percentage difference is 400 times, 400% or 500%. So therefore, my lord, inexplicably what is left is the rationale behind why you are not charging at all. And then, my lord, this cross subsidy surcharge is levied on a consumer, not on generator. So you cannot say our solar inda togotaro, ivrinda togotaro. Ultimately, they are using your network. So you cannot, then why should you distinguish it? Then, my lord, the other contention is that there was also a tariff. Sorry,
what else?
Tariff order, my lord, was already passed. Tariff orders are already passed. Iವ್ರೇನ್ ಮಾಡಿದ್ರು ಸೋಲಾರ್ನವರಿಗೆ ಮಧ್ಯದಲ್ಲಿ ಹೋಗಿ, ಐ ಆಮ್ ನಾಟ್ ಅಟ್ರಿಬ್ಯೂಟಿಂಗ್ ನೋಟಿಸ್, my lord, ಅವರಿಗೆ ಡಿಟರ್ಮಿನ್ ಮಾಡ್ದಂಗೆ ಹೋಗಿ ಅವರಿಗೆ ಒಂದು 6 ತಿಂಗಳಲ್ಲಿ ಆ ಟ್ಯಾರಿಫ್ ಆರ್ಡರ್ ಬಂದು 3-4 ತಿಂಗಳಲ್ಲೇ ಅವ್ರಿಗೆ 0 ಅಂತ ಮಾಡ್ಬಿಟ್ರು. So then what happened, my lord? Everybody started purchasing from him. Now I should also, one is, my lord, the hostile discrimination. How it caused prejudice is because ಎಲ್ಲ ಅವರಿಂದ ತಗೊಳ್ಳಿಕ್ಕೆ ಶುರು ಮಾಡಿದ್ರು. ನನ್ನ ಕೋಜನರೇಷನ್ ಇಂದ ಯಾರು ತಗೊಳ್ಳಿಲ್ಲ. Solar ಗೆ 0 surcharge ಇದೆ, ಎಲ್ಲ ಅವರಿಂದ ತಗೊಳ್ಳೋಣ, because the cost of power works out cheaper. Even to this date, some 2 years ago, my lord, it was 0. Now ಇದೆಲ್ಲ ನಾವು ಹೇಳಿ ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಗಳು ಹಾಕಿದ್ಮೇಲೆ ಈಗ ಏನೋ ತೆಗೆದು ಏನೋ ಕ್ರಾಸ್ ಸಬ್ಸಿಡಿ ಈಗ ಸೇವ್ ಮಾಡಿದಾರಂತೆ ಓಪನ್ ಆಕ್ಸೆಸ್ regulations ನಲ್ಲಿ. So, my lord, the cross subsidy cannot see the color of the power or the source of power. And then, my lord, the last contention is that, my lord, none of these contentions have been answered. Just 2 contentions have been answered. One is the license issue. Second is, my lord, in a very feeble manner, how that distinction is possible, quoting the Karya Power's judgment. So other than that, 5-6 contentions that I raised totally, my lord, are amiss in the order. So I
ವಾಪಸ್ ಕಳಿಸ್ಬೇಕು.
ಅಲ್ಲ ಬೇಡ ಸರ್, ಬೇಡ ಇವ್ರದ್ದು ಮತ್ತೆ ಬರೋದು ಅದೇ. So that's all, my lord, is my submission.
Yes, Shavas.
I'll answer.
Your Lordship, the main challenge in this petition is regarding the applicability of cross subsidy surcharge. And in order to avoid payment of cross subsidy surcharge, he is trying to bring up the issue of license, saying that you are not a licensee, so I will not pay it to you. Cross subsidy surcharge, Your Lordship, in essence says, if I'm a licensee, distribution licensee, and I supply power to poorer sections of society also, like farmers and other less privileged people. So when I supply power to those people, I supply at a discounted rate, and that discount, that subsidy, will be made good partly by the state government and partly by other consumers who can afford it. And this is called as cross subsidy. The higher end consumers, they can afford it, so they pay me extra bit of money, like 50 paise more than their tariff, so that I can give a 50 paise discount to the farmers. That's how it works. So if any consumer is taking power from me, I'm charging him 50 paise more so that I can subsidize the farmers. Now, if that consumer leaves my grid and goes takes power under open access, then I will be missing out on that 50 paise. Tomorrow, for example, if all of them leave my grid and take power directly from open access, I will not be having any money to subsidize the farmers who will have to take power from me only. And it is for this reason that the Act provides those who are migrating from my grid to somewhere else, they will have to pay me cross subsidy surcharge, which should be equivalent to cross subsidies. My consumers are also paying, and they should pay cross subsidy surcharge. So who subsidizes the farmers is the distribution licensee, and who should collect it? It's we. And there are many judgments of the Honorable Supreme Court on this issue. Your Lordship, the CESA satellite judgment itself squarely covers the issue. I'll just point out one paragraph. I'll just say 20 minutes, half the time that he took.
So yes,
Your Lordship, just Your Lordship, paragraph 30 in the CESA satellite judgment, page number 38, Your Lordship, of the memo of compilation.
You have also produced?
That's mine only, Your Lordship. He also relied on.
Yes.
Actually, I'm also relying only on CESA satellite. This judgment alone can decide the case.
Paragraph 30.
Page number 38 of the compilation.
Yes.
Paragraph 30, I'll read, Your Lordship. Supreme Court has defined what is CSS. Therefore, in the aforesaid circumstances, though CSS is payable by the consumer to the distribution licensee of area in question when it decides not to take supply from that company, but to avail it from another distribution licensee. In a nutshell, CSS is a compensation to the distribution licensee, irrespective of the fact whether its line is used or not. 15 minutes it took to say that my line is not being used. Someone else, he's not even a consumer. Because he's not my consumer, I'm levying CSS. If he was my consumer, I would have been levying CS, not cross subsidy surcharge, but only cross subsidies. The fact that he's not a consumer is working in my favor to levy CSS. I'll read. In a nutshell, CSS is a compensation to the distribution licensee, irrespective of the fact whether its line is used or not, in view of the supply, which would include an element of cross subsidy surcharge on certain other categories of consumers. What is important is that a consumer is situated in an area. In an area is bound to contribute to subsidizing a lower end consumer if he falls in the category of subsidizing consumer. Once a cross subsidy surcharge is fixed for an area, it is liable to be paid, and such payment will be used for meeting the current levels of cross subsidy within the area. A fortiori, so your lordship, he is located in my area, is not disputing. Hubli is in Dharwad, and that's why he's filed the case also in Dharwad. He is located in my area, so he has to pay the cross subsidy surcharge, and he is only trying to avoid. Now, your lordship, the main ground that he is taking is license, and his requirement to pay CSS has no connect to my license. But anyways, to avoid payment, he is taking the ground of license. Your lordship, before 2018, we've raised a demand on him for CSS because he was consuming power not from me. Even though he's a generator, he does not generate all the times. He only generates during his season, and for his startup purpose also he requires power. For that, he takes power directly from IEX, Indian Energy Exchange. He's not taking power from me, and that's why I'm levying cross subsidy surcharge on him. From 2018 onwards, interesting fact, from 2018 onwards, he's taken power from me by entering into a power purchase agreement with me as a distribution licensee. He says, I have the PPA attached, your lordship. Your lordship may see.
All right.
In the list of document, the first document that I've attached is a power purchase agreement. And I was not ready to sign the power purchase agreement. A group of petitioners who are before your lordship also, they approached KERC under section 86(1)(b), which is only a dispute between licensee and a generator. And there he deems me as a licensee, and he says, I'm producing power, I can't sell it anywhere. So I direct the ESCOMs to purchase power from me. And KERC passes an order to directing us to purchase power from them. And we enter into a PPA, and he sells power to us for 3 years. And he takes, and we pay him the tariff for those 3 years. So then we are a licensee when it suits him, because it's profitable to him. And when he has to pay the cross subsidy surcharge, he is not a licensee. He's approbating and reprobating only to suit his convenience, your lordship, and it is not maintainable. And your lordship, the main ground for a license that he has raised is that under section 14, even if I'm a deemed licensee, after the expiry of my license, I have to specifically apply for license. And unless I apply for that license, I cannot be considered as a licensee. And he says, my license expired in 2008. Post that I have not expired for renewal of license, so I'm not a licensee. Cessa Sterlite, your lordship, what he relied on, kindly see para 36, the first 3 lines of that judgment, your lordship. Yeah. Your lordship, we are in agreement with the aforesaid rationale in the impugned orders of the appellate.
Para 36.
46, sorry, your lordship. Page number 48.
I told you 46.
But the first 3 lines, your lordship, he read the last 3 lines on the issue of license. The issue of license. We are in agreement with the aforesaid rationale in the impugned order of the appellate tribunal, as that is the only manner in which 2 acts can be harmoniously construed. To recapitulate briefly, in the present case, no doubt by virtue of the status of a developer in SEZ area, the appellant is also treated as a deemed licensee. He's saying he's not a deemed licensee because he's not applied. He's saying Cessa Sterlite said he cannot be a deemed licensee because he's not applied for license. However, with this, it only gets an exemption from specifically applying for license under section 14. Supreme Court itself has said, here it gets an exemption from applying for license. It need not apply for license is what Cessa is saying. He's holding it to the contrary. What paragraphs he read are the paragraphs that APTEL had decided, and in appeal, Supreme Court held it to the contrary. Supreme Court said that you have to make they can be considered as a deemed licensee. Even if you're a deemed licensee, you have to pay CSS if you're not taking power from other licensees, what Supreme Court ultimately held. So, your lordship, the last argument on the license part, your lordship, kindly see the regulation 3.1.
No, but even I think APSRTC, sorry, AP Electricity, Supreme Court says it is a state under Article 12.
I have a specific. There is a fine distinction.
Your lordship, fine distinction in that.
State government alla anta.
Supreme Court says it is.
Your lordship may see.
The Supreme Court
If,
says
no,
in
no,
one.
I will, my lord, I will
Supreme
answer
Court
that.
In some, I
When
think that is
board-
Hinduja electricity.
Correct, my lord. I was the counsel in APRC on that.
ಮತ್ತೆ
No,
Hinduja
I'll
electricity-
submit, my lord.
In Hinduja electricity's case,
Correct.
Supreme Court considers
Please.
whether 100% government-owned company like Andhra Pradesh Electricity
Yes.
Company Limited there
Yes.
is a state under Article 12.
It is state.
Then it is appropriate government, state, everything. I think
Yes.
Supreme Court has held in that. Then that argument falls.
Illa, my lord. I'm respectfully submitting, my lord. I may be unsuited on other grounds. This, my lord, is the state government alla, appropriate government you agalla anta. It will be a company. Now, my lord, appropriate government agbekadre, you have to be a state government.
Hinduja judgment.
Yeah, I will. I'm sorry, my lord. I'll take it out.
Your Lordship, page number 407 of my compilation, exactly on this issue, there was a small paragraph of Supreme Court, which says that undoubtedly the appellant discoms are instrumentalities of the state and as such
Yeah,
is
this,
cited in the meaning.
this one is.
In the compilation that I have produced, Your Lordship.
This is
Page
Cesar Sterlite.
Not Cesar Sterlite. This is Andhra Pradesh Southern Power Distribution Company Limited.
Page.
Versus Hinduja, same, Your Lordship, same judgment. Page number 407. Hinduja judgment.
Three-judge bench adena.
Yes, sir. We are Hinduja judgment of Andhra Pradesh. Yes.
Oh, three-judge.
Page 407.
Andhra Pradesh Southern Power Distribution. Yes, yes.
Paragraph 116.
No, not 116. 116, huh?
Adral ide on the instrumentality of the state. We are
undoubtedly appellant discoms 116, my lord, distribution as such state within the meaning of so and so. Every action of the state is required to be guided by that. So they say state, not state government. I'm aware of this.
Your Lordship, under Proviso 3, if a state supplies power, then we need not apply specifically for license. And Proviso 1, what he's saying we covered under, it also does not say we have to specifically apply for license. Proviso 1, he read out to Your Lordship. He's reading into it, saying that because it does not exempt you from applying license, you have to apply for license. And he relies on a ratio of the APTEL. But Honorable Supreme Court in Cesar Sterlite, reading 14.1 itself has said that we need not specifically apply for license. And Your Lordship, this has been crystallized in a regulation by KERC in 2004. KERC in 2004, Your Lordship, the regulation is produced at page number 85 of the petition, and is challenged that 3.1 it says any person who is deemed to be licensed under the provisos of section 14 shall not.
I think Cesar Sterlite will decide the issue.
It will decide the issue. But
and also, my lord, there is one writ petition before Your Lordships now in 2024 Godavari. I'm sorry, I'm interjecting. There, my lord, the central government made rules. They understood this complication and made rules to say deemed licenseeಗಳಿಗೆ 25 ವರ್ಷ license anta. So that I have challenged, saying that what is not contained in the act. Now, my lord, our state agidra adan martirilla. They framed the rules for deemed licensees. That is also before Your Lordship.
State government elide, Your Lordship, if the regulation 3.1 is looked into, it clearly gives me a license as a deemed license, and I need not apply specifically. It says so. And he's challenged the 2004 regulation after a period of 21 years. And that too, after considering me, there is a clear acquiescence because he has executed PPA with me. After a period of 23 years, he is challenging the 2004 regulations. It's severely hit by the principles of delays and latches. Your Lordship, I will not trouble Your Lordship. I have produced many judgments to say that when there is an acquiescence coupled with principles of delays and latches, there cannot be a challenge to a statutory provision after a great efflux of time.
Demand equal.
Demand
regulation relate agide.
ನಾನು ಸುಮ್ನೆ ಚಾಲೆಂಜ್ ಮಾಡಬೇಕಿತ್ತು ಇವ್ರ ಲೈಸೆನ್ಸ್ ಅಲ್ಲ ಅಂತ ಡಿಮಾಂಡ್ ಇಲ್ಲದೆ ಇದ್ರೂ ಚಾಲೆಂಜ್
Yeah, because I don't want to.
Yes. What judgments delay you given, is it?
I have given Your Lordship. I'll just point out those judgments, Your Lordship.
Cesar Sterlite.
No, Cesar is on the point of
different. Yes. That's not both of you read.
Your Lordship may see page number 107, Your Lordship, of the compilation that I sent.
Not
107 of the compilation that I said. It's PGF Limited versus Union of India.
Oh, the para 37.
Para 37. It says, Your Lordship, this court can in the first instance examine whether there is a prima facie strong ground made out in order to examine the voice of provisions raised in the writ. Your Lordship, it says if you're only using challenge to a statutory provision to escape some other liability under the act, you should not do that, is what the sum and substance is. So your lordship, this challenge itself is not maintainable altogether. And that is on the point of license, your lordship. And we have clear license under regulation 3. We have been given license, and we have been given license for 25 years, not by the central government rules that he has challenged, but also by the state regulations of 2004. And that is not in dispute at all. And rest of the issues, your lordship, I've already filed my written submissions, and the Cessa Sterlite judgment covers it.
Lordships will see, my lord, I'm sorry, 108 of the Electricity Act, 107 and 108, the lordships will see. I'm saying this with conviction, my lord. The state government and central government are distinctly recognized entities under the act. Your lordships will see 107. In discharge of its functions, 107, my lord. In discharge of its functions, Central Commission shall be guided by such directions and matters of policy involving public interest as the central government may give it to in writing. And 108, state government can state government bere. Lordships will see 102 for a moment. Grants by the state government. 103
state government distinction
Allah, state government bere, state instrumentality bere, state owned distribution. No, I'm saying, my lord.
Power to issue directions by the government, central government and state.
Exactly, my lord. I am saying it's a separate entity altogether.
That will answer.
Yes, my lord. I'm
107, 108.
Sorry, man.
107, 108 ಬೇಕಾಗಿಲ್ಲ ಅದಕ್ಕೆ.
ಅಲ್ಲ ಅದಿದೆ 102, 3 ಇದೆ. And that APS, now my lord, if this is held to be a state government, it will have ಇದೇನೋ ಒಂದು ಆಗ್ಬೋದು, but there are fiscal implications of tax, etc., which my lord, the whole jurisprudence will be topsy-turvy. There is no, it can't be a state government, my lord. It can be an instrumentality.
He said it's a state government. Nobody can say it's a state.
What is exempted? Lordships will see, my lord, because I'm sorry.
Sir, state government is the one in definition which would perform sovereign functions.
Yes.
These people don't perform sovereign functions.
Marshal.
They are a state under Article 12.
Please.
Not the state government.
Please.
It's all right. Whether state under Article 12 would be,
yes,
license would be required or not, we will answer.
So therefore, not section 14 says appropriate government adan madbekar. In Pondicherry, my lord, government is doing it. The supply is done by government. And in many union territories, Diu Daman, it is done by the government. They are exempt. They don't take license.
Duties of the state being distributed to this ESCOM. State government ಮಾಡಬೇಕು ಎಲ್ಲ ಕಡೆ. ಹಂಗಿದ್ರೆ Article 12 other authorities ಬರದೇ ಬೇಕಾಗಿರಲಿಲ್ಲ.
ಅಲ್ಲ, this is privatized.
No. Other authorities ಬರದೇ ಬೇಕಾಗಿರಲಿಲ್ಲ. These are ESCOMs.
Correct.
ESCOMs are not private entities.
They are, my lord,
they are not
shareholder. They are not. I'm saying KPTCL is not.
It's not. It's a corporation.
It is too. But it is not government. It's not
statutory body.
Therefore, my lord, the exemption to take a license is only to such sovereign entities, not to these entities.
We'll answer that. Yes.
Your lordship, just the 2 points he said on the artificial arbitrary discrimination between solar.
But artificial intelligence.
Section 27(9). I'm sorry, my lord. 27(9) of the Reforms Act is one such provision which is not answered. ಅದನ್ನ ಮಾಡಿದ್ಮೇಲೆ ಏನೇ ಒಂದು ಟ್ಯಾರಿಫ್ ಮಾಡಿದ್ಮೇಲೆ ಅದನ್ನ ಪಬ್ಲಿಷ್ ಮಾಡಬೇಕು ಅಂತ. It cannot be. Your lordships will see.
Yes.
That is also not followed. This is not answered.
No, I'll reply to that. Your lordship, after the Electricity Act has been promulgated, any inconsistency between the KER Act and the Electricity Act will hold good. KER Act is saved only to the extent it is not inconsistent with the Electricity Act. The tariff determination process has been elaborately discussed under the Electricity Act, and the regulations framed under the Electricity Act also give out the procedure for tariff determination, and KERC has followed that. And because the KER Act, there are certain provisions which are inconsistent with the Electricity Act, he's saying that also has to be followed. They're just relying on hyper technicality to evade the payment of cross subsidy surcharge. And your lordship, to this day,
what's the amount?
50 crores, your lordship, in the all connected matters together.
It is even more. I'm not
100 crores.
That is not amount. Now, my lord, the other issue is
we have already subsidized
KPTCL's network is used or not, that he may clarify. ಈ ಅಮೌಂಟ್ ಹೇಳೋದು ರೈತರು ಅಂತ ಹೇಳೋದು, this is my emotive argument has no answer.
So I'll clarify, your lordship,
whether KPTCL's network is used or not, whether they
clarify. Cessa Sterlite very clearly says whether the network is used or not is
irrelevant. Network is used, you will be imposed CS.
CS.
Correct. Therefore, my lord, he can. ಈಗ ಅದನ್ನ ಮಾಡಲ್ಲ ಇವರು. ಈಗ
ನೆಟ್ವರ್ಕ್ ಯೂಸ್ ಮಾಡಿದ್ರೆ ಡೈರೆಕ್ಟ್ ನಿಮಗೆ ಕೊಡ್ತಾ ಇದ್ರು.
ಡೈರೆಕ್ಟ್ ಕೊಡ್ತೀವಿ.
ಕ್ರಾಸ್ ಸಬ್ಸಿಡಿ ಬೇಕಾಗಿರಲಿಲ್ಲ.
ಕ್ರಾಸ್ ಸಬ್ಸಿಡಿ my lord is at multiple levels, at transmission level.
Cross subsidy surcharge ಬರೋದು when you are not using their line, not using their network.
Exactly the point.
ಹೌದಲ್ವಾ?
Correct, my lord.
ಮತ್ತೆ why are you surprised?
No. If I'm
whether it is applicable or not.
No. I'll submit this, my lord. I am using their network, but I am not taking power from them. Therefore, I'm sorry, my lord.
I'll make that to be
not using, but not taking power from him. Because, my lord,
Sir, you are not taking power from him. He has an infrastructure established.
Correct.
You are using that infrastructure. When
No,
you
not
don't
using.
take, one minute, when
Sorry.
you don't take power from him, use that infrastructure.
Ha.
Even if you don't use that infrastructure, don't take power from him, CCS is applicable.
Yes, that is the.
That is his point, my lord. Now, what should
If it
happen
takes
to
power-
section
You
37?
straight away take power, CS is applicable.
And if it
Allah.
takes power from someone else and uses
No,
my network, separate wheeling and transmission charges are
that
applicable.
is
That is
wheeling and
separate. That is separate. I'm not levied on any wheeling charges or transmission charges on him because it's not used.
My lord, section 37.
Now, admittedly, you are not taking his network.
Yes.
You are not taking.
I am not at his network.
All right.
Correct, my lord.
You are in the geographical area, but you are
Yes.
not, you are
Oh,
not using his
correct,
network.
correct. I concede.
All right.
I concede.
So you are not taking power from him.
Yes.
So both are conceded. You are taking power from Indian Electricity Exchange, IEX.
I am drawing myself. Yes.
Not myself, drawing yourself, whatever.
Yes,
it is.
yes.
So there is nothing that you are doing with him,
Correct.
according to you.
I am paying wheeling charges to him,
No.
according to him.
Now, what
No.
is imposed on you is not wheeling charge.
Yes, that's the whole point, my lord. The surcharge can be imposed on wheeling charge. If the surcharge,
Subsidy, surcharge, and wheeling charges are two distinct.
two different things, my lord.
Two distinct things
Yes,
which
Lord.
they are entitled to impose separately. Whether that is CCS is applicable to you or not, we will answer it.
And your lordships will
But
see.
admitted fact is you are not using anything of them.
Yes.
Yes, that is not disputed.
That is not
That is a
disputed.
consensus.
That is not
Your lordships
disputed
will
at
see
all.
that. But then, my lord, if I use, then only it comes. Kindly see, my lord, section 42.5. Every distribution licensee, 42.4, State Commission shall permit a consumer or class of consumers to receive supply from a person other than the distribution licensee in his area of supply. Such consumer shall be liable to pay additional surcharge on the charges of wheeling.
That is additional surcharge, different, altogether different.
And your
Yes, that also.
then where does he trace this to, my lord? He may trace it to 3, probably 3, where any person whose premises are situated within the area of distribution licensee, not being so and so, requires supply from a generating company or a licensee. 3, my lord. Distribution licensee, such person may notice require distribution licensee for wheeling of so and so in accordance with regulations made by State Commission and duties of distribution licensee.
Sridhar Prabhu sir, wheeling is not the issue here.
Yes, my lord.
At all. That surcharge is different. We are paying or not. That's not the question. The question is cross subsidy.
Yes.
Cross subsidy.
Whether I am required to cross subsidize him or not.
CSS ಕೊಡಬೇಕಾ ಬೇಡವಾ ಅಷ್ಟೇ.
ಬೇಡ.
Because you are not drawing power, not drawing infrastructure, you're drawing power from somewhere else, but operating in the geographical area of the rest.
Yes.
That's all.
Yes.
That's the issue.
That's the issue.
And whether other issues, my lord, are not answered by the commission at all.
We'll see. When this core issue is there,
Yes.
incidental issues will answer.
Wait
Third reserved.
The lordship
What
has
is,
just
yeah?
filed a synopsis
Interim
of
order.
arguments. The interim order in the 50 crores in our payment.
And your lordships will see.
22 is the interim order.
22 in the, we've
ಅಲ್ಲ,
been trying to.
ಅದು ಬರೋದಿಲ್ಲ ನಾನು ಹೇಳ್ತೀನಿ ಟ್ರಾನ್ಸ್ಮಿಷನ್ ನೆಟ್ವರ್ಕ್ ಲಾರ್ಡ್ ಇಸ್ ದಿ ಕ್ರೈಟೇರಿಯನ್ ಅಂಡ್ ಯೋರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ವಿಲ್ ಸಿ ದ ಅದರ್ ರಿಟ್ ಪಿಟಿಷನ್ ಇನ್
So why you did not move this earlier? ಅವರೇ ಮೂವ್ ಮಾಡಿದ್ ನೀವು ಮಾಡ್ತಾನೆ ಇಲ್ಲ.
ಅಲ್ಲ ನಾವೇ ಮಾಡಿದ್ದು ಇದು ಈಗಲೇ ನಾವೇ ಮಾಡಿದ್ವಿ lordship. We've been trying to move.
2024
22, 3 years in the pending.
Pending, we moved multiple times, your lord. This time also we only moved, your lordship.
I thought Sridhar Prabhu sir moved.
ಇಲ್ಲ ನಾನು ಮಾಡ್ತೀನಿ
was very
ನನಗೇನು
That way he will
I don't seek
will
adjournment.
finish and
2024, my lord, I have challenged the rules because, my lord, lordship, I am not arguing this case. Lordships will see to remedy this situation, the rules have come. My respectful submission is, my lord, the central government has no power to transgress the act and then, my lord, confer that. ಅದು ಸ್ಟೇಟೇ ಅಂತ ಆಗಿದ್ರೆ ಇವ್ರು ರೂಲ್ಸೇ ಮಾಡ್ತಿರ್ಲಿಲ್ಲ. And my lord, Sesa Sterlite would have said,
ಗವರ್ಮೆಂಟೇ ಆಗಿದ್ರೆ ರೂಲ್ಸ್ ಮಾಡ್ತಾ ಇರಲಿಲ್ಲ.
that's what I-
ಸ್ಟೇಟ್ ಅವರು ಅದಕ್ಕೆ ರೂಲ್ಸ್.
ಅದಕ್ಕೆ ಅಲ್ಲ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಸ್ಟೇಟ್ ನವರು ಮಾಡಿದ್ದಾರೆ, ಸ್ಟೇಟ್ ಕಮಿಷನ್ ಹ್ಯಾಸ್ ಮೇಡ್ ಅಂಡ್ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಆಲ್ಸೋ ಮಲಾಡ್ ಹ್ಯಾಸ್ ಮೇಡ್. ಬೋತ್ ಆರ್ ಅಂಡರ್ ಚಾಲೆಂಜ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್. ಹೌ ಮಲಾಡ್ ದ ಆಕ್ಟ್ ಅಲ್ಲೇ ಇಲ್ಲದನ್ನ ಇವ್ರು ಮಾಡಬಹುದು ಅಂಡ್ ಸೇಸಾ ಸ್ಟರ್ಲೈಟ್ ನ ಟ್ರಾನ್ಸ್ಗ್ರೆಸ್ ಮಾಡಬಹುದು ಅಂತ, ದಟ್ ಇಸ್ ದ ಓನ್ಲಿ ಇಶ್ಯೂ. ಅಂಡ್ ಇಫ್ ದೇ ಆರ್ ಎಕ್ಸಾಮ್ SEZ, ಮಲಾಡ್, he read that paragraph which says it is addressed to the Sesa Sterlite saying that don't think you are a licensee. You have not applied for a license, you are not a licensee. Same thing is, my lord, holds good for him.
Need not apply ಅಂತಿದೆ ಅಲ್ಲಿ.
Need
Sorry,
not
my-
apply ಅಂತಿದೆ.
ಪ್ಯಾರಾ 46 ಅಲ್ಲಿ.
Need not apply ಅಂತಿದೆ.
Sorry, my lord,
Need not apply.
No, my lord, I'm sorry. If this
Correct.
my lord, is not the one which lordships may unsuit me. No, I'm saying this with conviction.
I'm not non-sure. I'm not non-sure.
ಇಲ್ಲ,
ಹೇಳಿದ್ದು
lordships will see,
46
my lord.
I think
No,
I've seen
46.
Not apply ಅಂತಿದೆ.
No, no.
46, your lordship.
Yes, I'm reading it, my lord, with your lordship. We are in agreement with the aforesaid rationale.
Whoever ಅಂತ ಶುರು ಆಗುತ್ತೆ ನೋಡಿ.
Yes, lordships will.
However, with this, it only
Yes.
gets exemption from specifically applying for license
Yes.
under 14.
You-
In other word, to avail further benefits under the act, the appellant is also required to show that it is in fact having distribution system and has number of customers to whom it is supplying electricity. We are supplying, we have the
No,
network.
no, lordships will see 44.2.
ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್ ಲೈಸೆನ್ಸ್ ಇದೆ, ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಇದೆ,
ಲೈಸೆನ್ಸ್ ಇಲ್ಲ.
ಸಪ್ಲೈ ಯಾಕಿಲ್ಲ?
ಇಲ್ಲ
License ಇದೆ.
ಅದೇ ಈಗ ನಾನು
ಇದೆ.
ಹೇಳ್ತಾ ಇರೋದು.
ಇದೆ, deemed
ಸೆಕ್ಷನ್
license
3
ಇದೆ.
ಪ್ರಕಾರ ಏನಿದೆ ಅವ್ರಿಗೆ?
ಇಲ್ಲ, lordships will see, my lord. Section 344, the 44.2 may be seen, my lord. Which are the entities who are not required to apply for license?
3 requires everybody to apply for license.
Yes, yes.
42 is an exemption. 42.3, right?
Sorry, my lord, the paragraph are you lordships referring?
ಈಗ 46.
46,
Anyway, we'll
yes.
look into it. Leave it.
46, yes, your lordship.
Yes.
46.
Huh.
To our previous paragraph, they discussed the finding of appellant.
Correct.
It is not their finding.
Is in
No,
my
if you
favor.
read Caesar Sterlite
Yes.
and the Andhra Pradesh judgment together,
Yes.
then an article, other authority under Article 12 also.
That is not the rationale in this one, my lord. Then, my lord, everybody will be ಈ ತರ ಮಾಡಿದ್ರೆ ಇವ್ರಿಗೆ ಏನಾಗಿದೆ, ಕ್ಯಾಪಿಟಲ್ ಇರೋಷನ್ ಆಗಿದೆ. ಇವ್ರಿಗೆ ಲೈಸೆನ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಮತ್ತೆ ಅಲ್ಲಿ ಹೋದ್ರೆ ಇವ್ರಿಗೆ ಸಿಗಲ್ಲ. Because there is no financial adequacy.
We'll consider it. Yes.
Leave it at that.
Heard reserved. Interim
Interim
order,
order.
any subsisting shall continue till the disposal of the petition.
Grateful.
Yes, next.
Bill number 5, Arjun Esrema.
Regularization.
Regularization ಆಗಿದೆ ಸ್ವಾಮಿ.
ಹಾ,
Their
ಏನಿದೆ?
claim is to consider their appointment from the date of initial appointment.
Initial appointment ಬರೋದೇ ಇಲ್ಲ.
ಅಲ್ಲ, earlier there was a proposal by the first respondent, my
10
lord.
years complete ಆದ್ಮೇಲೆ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ಅಲ್ಲಿ?
ಅಲ್ಲ, ಅದರಲ್ಲಿ page number 80 may kindly be seen, my lord. Annexure G, page number 79, relevant portion is at page number 80. Last parameter.
Regularize ಮಾಡಿದಾರಾ?
ಮಾಡಿದ್ದಾರೆ sir.
ಯಾವತ್ತಿಂದ ಮಾಡಿದ್ದಾರೆ?
As per annexure.
As per ಬೇಡ, ಯಾವತ್ತು ನೀವು ಜಾಯ್ನ್ ಆಗಿದ್ದು ಯಾವತ್ತು ಹೇಳಿ?
My lord, it is from
Initial appointment date?
it is, ma'am.
There are many petitioners, your lordship, 83, 81, 81.
ಅಲ್ಲ, ಜನರಲ್ ಡೇಟ್ ಹೇಳಿ ಮೇಡಮ್. 1981 ನಾ?
82, 83, your lordship.
ಆಯ್ತು, 81, 82, 83. ರೆಗ್ಯುಲರೈಸ್ ಆಗಿದ್ದು ಯಾವಾಗ?
96, ma'am.
With effect
from the date of order, my lord.
From the date of order.
ಇಲ್ಲ, they are claiming from the date of appointment. your
Date of
lordship.
appointment you will not get it all.
ಅಲ್ಲ, ಅದರಲ್ಲಿ
Of
page number
absorption.
80 ದಲ್ಲಿ what happened, my lord, there was a proposal sent by the
Proposal, illegal.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಯಾಕಂತಂದ್ರೆ ಲಾಸ್ಟ್ ಪೇರ ಒಂದಿಷ್ಟು ಒಂದು
ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಡೇಟ್ ಆಫ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇಂದ ಮಾಡಬೇಕು ಅಂದ್ರೆ ಇಟ್ ವಿಲ್ ಬಿಕಮ್ ರೆಗ್ಯುಲರ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ರೈಟ್ ಫ್ರಮ್ ಡೇ 1.
That's why, my
There
lord.
is no necessity for
ಅಲ್ಲ,
regularization.
that's why, my lord, the page number
No.
page number 80, my lord, last para.
Sir, were you not appointed on nominal muster rolls?
Subsequently, we have been
ಮತ್ತೆ?
converted into an MRE, my lord. And earlier, my lord, this court has directed to consider. ಅಲ್ಲ, in terms of annexure G and H, my lord.
Oh, no, sir. ಅಷ್ಟೇ, ಆಮೇಲೆ it will open Pandora's box. The moment an order is passed saying that you should be regularized from the date of initial engagement and not 10 years completion, finish.
ಅದರಲ್ಲಿ
It
ಒಂದು
will drain the state governments completely.
ಅದರಲ್ಲಿ ಒಂದು ಪ್ಯಾರಾ ನೋಡ್ಬಿಟ್ರೆ page number 80 ಲಾಸ್ಟ್ ಪ್ಯಾರಾ ನೋಡಿಬಿಟ್ರೆ
ಕೊಡಿ, ಏನ್ ಹೇಳಿದ್ದಾರೆ?
ಈ ಪ್ರಾಧಿಕಾರದ ಸಿಬ್ಬಂದಿಗಳು ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳು 1987 ಜಾರಿಯಾಗುವ ಪೂರ್ವದಲ್ಲಿ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳನ್ನು ಬಾಕಿ ಇರಿಸಿ ವಿವಿಧ ಮಂಜೂರಾತಿ ಹುದ್ದೆ ಮೇಲೆ ನೇಮಕಾತಿ ಹೊಂದಿದ ಎಲ್ಲಾ ಸಿಬ್ಬಂದಿಗಳು ಪ್ರಾಧಿಕಾರದ ಕಾಯ್ದೆ 1980 ಸೆಕ್ಷನ್ 11(2) ಮತ್ತು ಕಾಡಾ ನಿಯಮಗಳು 85(2) ಪ್ರಕಾರ ಅವರುಗಳ ಸೇವೆಯನ್ನು ದುನುಗುಲಿ ಆಧಾರದ ಮೇಲೆ ನೇಮಕಗೊಂಡ ದಿನಾಂಕದಿಂದಲೇ ಸೇವಾ ಸಕ್ರಮತೆ ಮಾಡಿ ಅವರ ವೇತನಗಳನ್ನು ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ನಿಯಮಗಳು 42(b) ಅನುಸಾರ ಮಂಜೂರು ಮಾಡಲು ಅವಕಾಶವಿರುತ್ತದೆ. ಕಾರಣ, ಸಿಬ್ಬಂದಿಗಳು ಉಲ್ಲೇಖಿತ ಮನವಿಯಲ್ಲಿ ಕೋರಲಾದ ಅವರ ನೇಮಕಾತಿ ಹೊಂದಿದ ದಿನಾಂಕದಿಂದಲೇ ಸೇವಾ ಸಕ್ರಮತೆ ಮತ್ತು ಅಂದಿನಿಂದ ಆರ್ಥಿಕ ಸೌಲಭ್ಯವನ್ನು ವಿಸ್ತರಿಸಿ ಮಂಜೂರು ಮಾಡಲು ಅನುಮತಿ ನೀಡಬೇಕೆಂದು ಈ ಮೂಲಕ ಕೋರಲಾಗಿದೆ. It was sent by the first respondent only, director of the administrator of the CADA, my lord. That's why, my lord, earlier accusation, my lord.
Not the law.
ಅದರಲ್ಲಿ that's why, my lord, we are before
CADA
this.
administrator is not the law.
And ಅಲ್ಲ, he is the only person, my lord, who has to.
He is not the law ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, as per section
Law
5
is different.
and moreover, my lord, page number 84 also.
Oh, sir. ಇದು ಒಪ್ಪಿಟ್ರೆ ಆಯ್ತು ಆಮೇಲೆ. Oh, most dangerous
Earlier, my lord, there was direction to
No, no, sir.
consider.
No, 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 no.
I'm seeking only for remanding of the order, my lord.
No, no, sir. Not. The dangerous proposition. 10 ವರ್ಷ, that is, every government order, even Supreme Court recognizes. 10 years.
We are before this court, my lord. Only because of that proposal sent by the first respondent, my lord. That's why earlier also, my lord, the same direction was given to consider in terms of annexure J and H.
Reject ಮಾಡಿದಾರಲ್ವಾ?
Reject ಮಾಡಿದ್ದಾರೆ, sir.
Not from the date of initial engagement, regularization unknown. Regularization ಯಾಕೆ ಬೇಕು? Regular employment ಆಯ್ತು.
ಅದರಲ್ಲಿ there was no C and R rules, my lord. Pending.
ಗೊತ್ತು, ಕಾಡಾ ಫಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾಗ C and R rules ಇರಲೇ ಇಲ್ಲ.
ಹೌದು ಸರ್. That's why, my lord, that para was.
10 years ತಗೊಂಡಿದ್ದಲ್ಲ regularization, be happy.
ಎಲ್ಲ ತಗೊಂಡು.
You are all regular employees now, you are getting everything. Be happy with that.
Some of them have already retired from service.
Then
only for monetary benefit, my lord, they are before this one.
Oh no. Anything else? The petitioners in all these cases project a singular grievance that the cases of these petitioners who have all been regularized now ought to have been regularized from the date of their initial engagement and not completion of 10 years of service. Skeletal facts necessary for the consideration of the issue in the list are as follows. I'll mail a hard so and so on that. On 12/3/1996, the cadre and recruitment rules of the CADA-TBP come into force. After the C&R coming into force, the employees who were engaged in the services of CADA of whatever time it would be, right from 1980 to 1996, were all absorbed into the services of CADA. The petitioners then are said to have submitted representations to the respondent contending that they are entitled to regularization or absorption from the date of their initial engagement, i.e. in the year 1980 to 1990 onwards. The said representation merited a recommendation from the hands of the competent authority, hands of the administrator.
First
respondent to the state government. The recommendation.
It is a board, my lord.
A board, all right. Board to the state government. The recommendation remained a recommendation. Therefore, the petitioners approached this court in writ petition 108803 to 108825 of 2014. A coordinate bench of this court disposes the said writ petition by the following order. The coordinate bench directed consideration of the representation of these petitioners in accordance with the recommendation that was made by the board to the state. The direction to consider the representations has resulted in the impugned order and the impugned order in the subject petition. The learned counsel appearing for the petitioner submits that the petitioner's services which were engaged from 1980 onwards for more than 3 or 4 years should be reckoned for the purpose of calculation of qualifying service and all other benefits, which would mean that it should be the service rendered by these petitioners at the time when they were appointed as daily wage employees or MRE later should be taken note of as service. The said submission is refuted by the learned HCGP contending that if this submission were to be accepted, every employee who has been regularized after completion of 10 years of service in accordance with law will approach this court seeking regularization from the date of the initial engagement, which will open Pandora's box. In the light of the aforesaid submission, what is necessary to be noticed is whether these petitioners who are regularized in the year regularized/absorbed into the services of CADA in the year 1996 are entitled to count their service from the date on which they were initially engaged, all on the basis of a recommendation by the CADA to the the state government. The answer to the said submission would be an unequivocal and an emphatic quote unquote no, for the reason that the petitioners were engaged as daily wages, later on MRE basis, and worked for a period of 10 years or more. When the cadre and recruitment rules sprang in the year 1996, absorptions sprang. That would not mean that every daily wage employee who was engaged in the absence of cadre and recruitment rules should become a regular employee from the date on which they were engaged on daily wages. This would run counter to scores and scores of judgments and government orders issued by the state, including the judgment of the Constitution Bench in the case of Uma Devi, 2006 4 SCC page 1, where the apex court recognizes the concept of regularization, absorption, to be from the date on which they completed 10 years of service, which has been done in the case at hand. The employees have been regularized appropriately after completion of 10 or 12 years, as the case would be, and few of them have all retired from service. The claim is now for monetary benefits for the 10 years or 12 years they worked as daily wages. The prayer of the petitioners, if granted as contended by the learned HCGP, would open a Pandora's box and unsettle all settled claims, and resurrect all settled claims of regularization for decades. Therefore, there is no warrant to consider the case of these petitioners. The petition lacking in merit stands disposed.
All three matters.
Number 6.
ಏನ್ ಮಾಡಿದ್ರಿ?
Kindly have it on Monday, my lord.
ಆಯ್ತು, ತೊಂದರೆ ಇಲ್ಲ. ಏನ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
They have written to the university for grants, to pay the wages, my lord.
Monday.
Monday.
Please. List on Monday. Yes.
Bill number 7.
Kindly posted on Friday, my lord. YSS ready come physical, my lord.
Right.
My lord, this is covered your worship, I have considered.
ಯಾವುದು 21 21 ಇದು?
ಇಲ್ಲ, 12(3), my lord, with regard to, my lord, registration of another cooperative society.
Oh, same name. Long back covered. Division bench also affirmed.
Friday ante ಅವರು
Friday.
Monday. List on Monday in fresh matters list. Covered, close mark.
Bill number 8. Raghavendra Purohit.
Please. 482, my lord, for quashing the proceedings in SC number.
Opponent GD Patil.
He is held up in quotal number 6, my lord.
Barli, pass over.
Please.
Promise of marriage, Allah?
Please.
What's the issue?
It is, my lord, a promise to marry.
ಅದೇ ಕೇಳಿದ್ನ. Yes.
It is covered by decision of.
Oh, correct, sir. Pass over. 230.
Please.
Bill number 9.
My lord, I'm for the respondent and the short accommodation, please. Senior is out of station.
Yes. Yes. List the matter on Tuesday. Yes.
Bill number 10. Srinande Pachapure. Shirasi Bellaki.
Appear for the
Appear for the Respondents' Council.
Yes, sir.
It is sought to be projected that it is covered by a decision that is not so, my lord, but we are ready for our.
Let the senior counsel submit. Yes, sir.
ಹೇಳ್ತೀನಿ ಆಮೇಲೆ.
Yes, yes.
Annexure B page
There is
17,
a-
it starts.
ಉತ್ತರಾಧಿಕಾರಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ದಾರೆ.
ಒಂದು ನಿಮಿಷ. Petitioner counsel ಮುಗಿಸ್ಲಿ.
ಅಲ್ಲ ಆಗ್ಲಿ, ಅದಕ್ಕೆ ಹೇಳ್ದೆ. ಆದ್ರೆ ಕವರ್ಡ್ ಬೈ ಡಿಸಿಷನ್ ಇನ್ ಕೇಸ್ ಅಲ್ಲ.
ಅಲ್ಲ ಆಯ್ತು, ಲೆಟ್ ಹಿಮ್ ಸ್ಟಾರ್ಟ್.
ನಾನು ಇನ್ನೂ ಹೇಳಿಲ್ಲ ಅದನ್ನ. Annexure B page 17 to 20 minutes. It's a registered deed. It's a registered deed appointing the petitioner as the successor Mathadipati by the second respondent.
Page.
It starts from page 17 and page 18, the recitals commence. Uttaradhikari Nemanuki Patra, which is not in dispute. This is not the list, my lord. Now, the list is after 4 years of this registering this document, the second respondent unilaterally cancels and registers that cancellation deed, which is not a challenge before your lordship.
Second respondent yaru?
Mathadipati, my lord. The senior pontiff.
ಅಲ್ಲ ಸೀನಿಯರ್ ಪಾಂಟಿಫ್ ಇದ್ದಾಗ ನಿಮ್ಮ ಜೂನಿಯರ್ ಪಾಂಟಿಫ್ ಅಂತ ಮಾಡಿದ್ರ ಪಾಂಟಿಫ್ ಅಂತಾನೆ ಮಾಡಿದ್ರ?
ಅಲ್ಲ, ಜೂನಿಯರ್ ಪಾಂಟಿಫ್ ಅಂತ ಫಸ್ಟ್ ಮಾಡಿದ್ರು.
ಹಾ.
Then my contention is after 2 years, I was coronated as the Mathadipati or Peethadipati.
Where is that? That is the condition in that.
No, that's not the condition, but I have produced documents to show.
Sir, if I have understood.
Please, minutes.
Now, this is the senior pontiff, respond number 2.
Please, minutes.
He executes a deed.
Deed.
He executes a deed anointing you
As the successor Mathadipati.
successor Matadipati.
Please, minutes.
The successor would become after him or?
No, successor would become after
After him.
Please.
So now, in the interregnum, he is still there.
He's still there.
In the interregnum, he wriggles out of it and says that I have not.
And cancels on the ground that you are not fit for that post after 4 years. And
There fitness certificate. Right.
there was a first round of litigation wherein the
And he
trial
has,
court and
he
the
has filed a suit.
ಅಲ್ಲ, ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. The suit that I had filed to declare this cancellation deed as void and not binding on the plaintiff. An order of injunction which was sought for, refused by the trial court, first appellate court. This honorable court was pleased to cancel both the orders and confirm that I continue to be the Uttaradhikari. And the status quo is to be maintained by both the parties.
Then suit ಅಲ್ಲಿ ತೀರ್ಮಾನ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ಇದೇನಂದ್ರೆ, when once a bilateral document is registered, unilaterally it cannot be cancelled is the principle which is laid down by this court, though under the Contract Act, section 62 of the Contract Act.
Talking of novation.
And even, my lord, in the matters relating to the succession, the Supreme Court was categorically pleased to hold that there cannot be an arbitrary or unilateral cancellation of the succession deed. That's the law laid down by the Supreme Court. Therefore, now that the matter is pending, I do not deny that. But the office had raised an objection that how this writ petition is maintainable in view of the pendency of the suit, wherein
Officer of the objection raised. Office objection sustained.
Office had taken over the role of.
Office objection was overruled by this honorable court.
Obviously, why can office say all that?
We should only thank that because the officers have become more also equally intelligent.
Yes, sir.
So, but I do understand that in a suit pending, wherein the same prayer is already there, I can hesitate that there also. But my humble submission to Lord's kind consideration is.
Why do you invite findings, sir, here, which would become binding? A finding here will become binding.
I understand, minutes.
Then.
In that event, in view of the law declared already on this very point, instead of participating in the rigmarole of evidence and years.
Adkodi, we'll consider and close this. There is a law declared here already.
Yes, Melody. Here, I have produced the judgment, Melody.
That is page 40.
Yes, Melody.
Justice Magdum ordu.
Justice Magdum. And His Lordship Justice Magdum was pleased to overrule the office objection and hold. My Lord may kindly peruse the order sheet dated 2nd of July 2024.
That's all right, but this is covered.
This is covered anta namdu yakendre a bilateral document, maybe the facts in that case may be different, but the principle of law is a bilateral document which is registered cannot be unilaterally cancelled is the law laid down by the single judge and confirmed by the division bench. Page 49, fourth line may kindly be seen, my lord. Page 49. Therefore, a registered deed cannot be unilaterally cancelled by its executant is the law laid down. There it was a power of attorney coupled with interest. I understand.
GPA coupled with interest.
Coupled with that.
When GPA coupled with interest is executed, unilaterally
section 202 of the Contract Act comes into play. Here, I'm not holding that section, relying upon section 62. That's.
ಯಾಕೆ ನಿಮ್ಮ ಮೇಲೆ why love was lost?
I'm at a loss to say anything about that, but this honorable court in the previous round of litigation, which is a copy of which is produced by the respondent in the detailed statement of objections, was pleased to hold that allegations were too vague.
Allegations?
Were too vague. Allegations to.
Allegations ಮೇಲ.
Allegations ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ, ನಮಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ. without any show cause notice or without holding any inquiry, that decision was taken under Annexure A. Page 85 of the statement of page 85 of the paper.
Justice Ravi Hosmani ಅವರ order.
ಹೌದು, ಜಸ್ಟಿಸ್ ರವಿ ಹೊಸ್ಮನಿ ಅವರ ಆರ್ಡರ್. ಅದರಲ್ಲಿ ಇಟ್ ವಾಸ್ ಹೆಲ್ಡ್ ಇನ್ ಫೇವರ್ ಆಫ್ ದಿ ಪಿಟಿಷನರ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಆಲ್ಸೋ.
Writ appeal is confirmed. Writ appeal ಅಲ್ಲಿ.
Not in that, but that was the same GMCPC.
Oh, GMCPC.
That was GMCPC. So in this
Supreme Court ಹೋಗ್ಲಿಲ್ವಾ?
ಹೋಗಿಲ್ಲ. Because the status quo was ordered to be maintained by both the parties till the disposal of the suit. And my lord, an issue was framed about the maintainability of the suit. Contrary to this order of jurisdiction being held in favor of the plaintiff on IA number 3, then my lord, about a week ago, my lord, the coordinate bench of this honorable court was pleased to stay that order on IA number 5, my lord, seeking the deletion of that issue on maintainability. That's a separate issue, my lord. In this issue, I'll only confine myself to the principle of law laid down by the Supreme Court, not under the Contract Act, but under the Hindu Religious and Charitable Endowments Act also. May I bring to your lordship's kind notice? Yes, sir. 1974-1 SCC.
So that's all the issue in this.
That's the only issue, my lord. 1974-1 SCC. And the specific point is that in detail, in depth, deals with the British precedents also, and canon law, and Indian law relating to Religious and Charitable Endowments Act, with specific reference to the appointment of a successor and cancellation. The facts are identical in that case to the facts of this case also. Paragraph 8 may kindly be seen. The same, by a will, the plaintiff in that case was appointed as successor. By another will, it was cancelled, which was challenged before the court below.
Again, it is by deed.
Yes, by a registered deed. I'll read only paragraphs 8 to 10 and then read directly.
Yes.
It's on page 155 minutes.
Yes.
The division bench reversed the decree passed by the learned single judge on the basis of its finding that appellant did not become the holder of an office by virtue of the nomination, and so it is open to the defendant to cancel the nomination without notice to the appellant and without assigning any reason. It's against this decree that this appeal has been preferred by special leave. The questions which fall for consideration in this appeal are whether by virtue of the nomination, the appellant obtained a status or a right in law or became the holder of an office, and whether the defendant was competent to cancel the nomination without good cause. Where the law laid down the consideration of these issues is in at page 160, starting from paragraph 22.
Yes, sir. Para 36 is the crux, 3 lines.
Yes, I wanted to come to that one. But para 36 to 40, the whole issue is covered.
36 at his sweet will and pleasure.
Yes, no, it can't be done, which is precisely the case in this case. And there is already a finding by the coordinate bench that the allegations were too vague. And therefore, this document deserves to be interfered by your lordship and cancelled. Notwithstanding the prayer made, and I undertake that once the order is passed by this honorable court, I'll withdraw that prayer, the first prayer in the suit. That's my submission.
Yes. Yes, sir. Unmute, Madak. Unmute, sir.
Please. It's a case wherein ನನ್ನ ಪಾಶ್ಚಾತ್ ಉತ್ತರಾಧಿಕಾರಿಯಾಗಿ ಮಾಡಿದ್ದೇನೆ. After my death, you are to take over. This person, immediately after 1 year or so, arranges a public function wherein he declares that he has already taken over as Pitadipati. He announces a civil death to the present Matadipati. If that cannot be a reason for cancellation, it's a matter for evidence. I would only rest it at that. In MFA, specifically it is said, you are no more claim anything like Uttaradhikari or anything. You are like any other devotee. There is a room given to you in the mutt. You may use it. Nothing more than that has been granted in the appeal. He should come to mutt or participate in any function only as a devotee. That is the order in the civil court. Whether I had good reason or bad reason, etc., is a matter of evidence. I would respectfully submit, after having filed the suit, specifically saying this cancellation is bad for any reason, question of that being inquired in a writ petition will not arise. In case the matter is to be inquired, I would say it's a case which requires evidence. Therefore, it is not at this stage that my learned friend could seek any remedy in the writ petition. The judgment which my learned friend has relied upon may kindly be seen. That was a case where husband and wife, a power of attorney was executed. That was challenged in a suit. Suit was dismissed. After dismissal of the suit, he wanted the document to be registered, cancellation document to be registered. Unfortunately for him, the sub-registrar issued an endorsement saying it is coupled with interest, I am not registering it. That endorsement was challenged. This honorable court said, it's as the suit is already dismissed, it's a two-way document coupled with interest. Therefore, the endorsement issued by the sub-registrar is proper. Of course, I would still have reservation about the way in which that was done, but it was on facts in respect of a document between husband and wife. Where,
Yes.
apart from all other considerations, several family, this thing, all those things will come into picture.
Yes. This judgment of Supreme Court? You
No,
have
this
anything
is
to say in
not
this?
the judgment of Supreme Court. This is the judgment of
ಇದು ಇನ್ನೊಂದು
judgment
ಕೊಟ್ರಲ್ಲ
of the
ಅದು.
Supreme Court. Supreme Court only says it can be done. It should be done for a reason, which should be you should be able to prove it. That requires evidence. The very fact that during my lifetime he anointed himself, proclaimed that he is the Matadipati, took over, and he tried to oust me.
ಅಲ್ಲ ಇದು ನಿಮ್ದು ಆಫ್ಟರ್ ಯುವರ್ ಡೆತ್ ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
I would submit.
ಯಾವ್ದು which page?
Annex B minute.
Past chart, your lordship may kindly see.
Where is that?
Please.
ತಪ್ಪದೆ ಉತ್ತರಾಧಿಕ
ಅದು page 19.
Page 19, last para, my lord, unnumbered last para.
ನನ್ನ ಪಾಶ್ಚಾತ್ yes.
Yes, paschat. I'm not disputing that fact. But one fact which I would wish to controvert is, it is factually incorrect that the petitioner before your lordship anointed himself and declared himself to the Patadikari. No, it is with the participation of the second respondent. There are a lot of photographs shown. I will not press those points because it's a matter of evidence. I will have to establish that in evidence. All that I say is the finding that is recorded. My lord may kindly permit me to read one paragraph from His Lordship Justice Ravi's order. Paragraph 29, page 87 of the statement of objections.
Justice Ravi Osmani.
Please, my lord. It's produced by the respondent.
Here.
Page 87.
Yes.
Paragraph 29. On perusal, it is seen that there is assertion in the plaint about appointment of plaintiff as Uttaradhikari on 25/7/18, which is admitted, holding a function on 22/2/2020 and attendance of defendant in the said function in tandem with newspaper reports that function organized was for appointing plaintiff as Pattadhikari, would prima facie establish plaintiff's case. On the other hand, defendant denies plaintiff's appointment as Pitadhikari and claims cancellation of appointment as Uttaradhikari was for good reasons enumerated in resolution passed on 11/11/2022 at Annexure R1. But, well, this is the finding, but perusal of the same would indicate that the allegations are without material particulars and thereby falling foul of ratio in Bhimsenacharya's case, and weighing total denial as against material produced by the plaintiff would
But
not be justified.
everything is at large before the civil court. Why should we?
It was,
Why
it was
should
at
we
the
be
stage of interim application.
No, my lord, the prayer is there before the trial court, which I do concede, my lord. But in view of the law already declared by the Honorable Supreme Court, should the parties be again put to the rigmarole of the long, my lord, the process of recording of evidence and the lot of time to be spent before both the courts, and therefore my humble submission is, in terms of my lord, Article 227 of the Constitution, this court, which has got superintending power over all the courts and tribunals, can interfere in this case as an exception in view of the law laid down by the Supreme Court. That's my humble submission.
ಎಲ್ಲ ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳೋದು ಒಳ್ಳೇದು. ಸುಮ್ಮನೆ ಫೈಂಡಿಂಗ್ ಅಗೇನ್ಸ್ಟ್ whatever. What I may write is a
No, I
different
understand. In which event, may I make a humble request, my lord? Can this issue be tried as a preliminary issue? If your lordship would be pleased to direct the trial, where in the suit itself, my lord?
What preliminary issue?
Preliminary issue as to whether the issue of the unilateral cancellation has already been decided, and therefore
That can't be tried as a preliminary issue. You would
That
require
is the
evidence.
substantial
The
issue.
entire spectrum of facts and preliminary issue, final issue.
No, not that.
To be
Both,
tried
both,
together.
it is an admitted fact by both the sides.
ಈಗ
And this court,
maintainability issue delete ಮಾಡಿದ ಸ್ಟೇ ತಗೊಂಡಿದ್ದೀರಾ?
ಹೌದು, maintainability, because there is already an order on maintainability on IA number 3, and it operates as res judicata at an interim stage ಅಂತ.
ಅಲ್ಲಿಂದಾನೇ ಒಂದು ಡೈರೆಕ್ಷನ್ ತಗೊಂಡ್ಬಿಡಿ ಅದನ್ನ. Yes,
I leave it to you.
everything.
I leave it.
Because plural remedy is not according to.
No, parallel remedy, my lord, is certainly a case which comes against me. I am conscious of that. I was only, my lord, trying to impress upon your lordship about the invocability of Article 227 in the facts and circumstances this case.
227.
227.
AMCPC. 226. Yes. We'll close it, sir. We'll close it.
Please, my lord.
The petitioner is before this court seeking the following prayer. Heard the learned senior counsel Gangadhar R. Gurumat appearing for the petitioner and the learned senior counsel Jaikumar S. Patil representing the respondent. The issue at this juncture in the subject petition as projected lies in a narrow compass. The petitioner is said to have been anointed as a Pitadhikari of ಯಾವ ಮಠ ಇದು? ಉತ್ತರಾಧಿಕಾರಿ of
Shivananda Math Gadag.
Shivananda Math Gadag, through a deed that was executed from the hands of the second respondent, who was the then Mathadipati.
Senior Mathadipati.
Senior
Who is now also.
Senior Mathadipati. They would be referred to as the senior pontiff and the junior pontiff for the sake of convenience. The senior pontiff, owing to his age and other manifold circumstances, executes a deed of bringing in the junior pontiff as the Uttaradhikari post his demise. The deed reads as follows, page 18-19. The deed is unequivocal that the petitioner would get the right to become or would be the Uttaradhikari after his death. This is not in dispute. The issue is, after execution of the said deed, it transpires that the second respondent does a volte-face by cancel ಮಾಡಿದ್ರ ಅದನ್ನ?
Please,
by cancelling the said deed.
Annexure A.
By cancelling the said deed, which is
unilaterally.
The volte-face unilateral.
Oh, yes, ma'am.
Cancelling the said deed. Unilateral, yes. The challenge is to the cancellation of the deed. The learned senior counsel for the petitioner submits that it is settled principle of law that a deed validly executed, i.e. a bilateral deed, cannot be cancelled unilaterally. the learned senior counsel would try to bring in, would want to bring in. Learned senior counsel submits that the concept of contract would become applicable to the case at hand as well, as there cannot be cancellation of a contract which was entered into between two parties by a single party to the contract. The learned senior counsel further submits that a civil suit has been filed on the challenging the very cancellation of the contract, but if this court would decide the issue, the rigmarole of trial would be obviated, and therefore submits that this court should entertain the petition and answer the simple issue as to whether there could be unilateral cancellation of a contract, unilateral cancellation of a bilateral contract. The learned senior counsel for the respondent would again take this court through the documents appended to the petition and the statement of objections to demonstrate that the petitioner's right to become an Uttaradhikari was only after the demise of the second respondent, the executant of the document. Before that, no right of him to become an Uttaradhikari can be claimed. The reason for cancellation is that the petitioner anointed himself as a Uttaradhikari even when the second respondent was alive. Therefore, the cancellation had to come about. He would submit that suit in OS 45 of 2022 challenges the very same action. Therefore, the parallel remedy should not be permitted to be entertained at the hands of this court. The learned senior counsel for the petitioner would now join issue in placing reliance upon the judgment rendered by the coordinate bench in writ petition 103965 of 2023, by which the coordinate bench holds that a document that was executed cannot be cancelled unilaterally. The learned senior counsel would submit the issue in the list is identical to what was decided by the coordinate bench. I have given my so the four narrated facts.
May I interrupt? Yes, sorry. That order of the single judge is confirmed by the division bench, which is also produced by the respondent.
The learned senior counsel would further submit that the order that he places reliance upon to buttress the submission as aforesaid is affirmed by the division bench as well, and therefore the findings in the order have become final. I have given my source. The aforenarrated facts are not in dispute. The deed executed is quoted herein above. The deed was unequivocal that the petitioner would become Uttaradhikari after the demise of the second respondent, the executant of the deed. The cancellation comes about on manifold circumstances, as is indicated by the learned senior counsel or the averment in the statement of objections. This court would not go into those circumstances at this stage, as the issues are as the suit in OS 45 of 2022 on the same cause of action is preferred by the petitioner, and the matter is set at the stage of evidence. Please, suitally.
Evidence is to be commenced.
Issues are framed and matter is set at the stage of evidence in the said suit. The reliance being the only issue is the order passed by the coordinate bench, which is affirmed by the division bench as quoted herein above, to become applicable to the facts of this case for entertainment of the petition, notwithstanding the pendency of the suit in OS 45 of 2022. The coordinate bench has held as follows, para 8 till the end. The issue therein was the sub-registrar not registering the cancellation of the general power of attorney, on the score that the general power of attorney did come about coupled with interest. In the light of the GPA being with interest, coupled with interest, a unilateral cancellation by the executant was not found favor with the learned single judge, and the not finding favor at the hands of the sub-registrar was affirmed by the coordinate bench. The said judgment is distinguishable without much ado in the case at hand. In the case at hand, the document was clear that it was to be the anointment or coronation of the petitioner as Uttaradhikari would emerge only after the death. The reasons for the cancellation, as averred in the statement of objections, I deem it appropriate not to enter into the reasons assigned for cancellation as averred in the statement of objection or otherwise, as all those matters would require evidence. And the matter in OS 445 of 2022 is at the stage of evidence. In that light, without expressing any opinion, except the fact that the judgment relied on by the learned senior counsel of the coordinate bench would not become applicable to the facts of the case. The Supreme Court would not become applicable to the facts of the case. The learned senior counsel has further placed reliance upon the judgment of the apex court in the case of so and so, where where a will is executed as the successor of a mutt, and the will is cancelled. The cancellation of the will was the subject matter of the proceedings before the which reached subject matter of proceedings which reached the apex court. The apex court no doubt holds that the cancellation cannot be at the sweet will and pleasure of the head of the mutt there who had executed the will. The said judgment at this stage would not render any assistance to the learned senior counsel in the light of the fact that all the issues are pending before the civil court. There is this court has no reason to believe that the civil court would not look into the judgment that is relied on by the learned senior counsel for the petitioner in the case of 1974 1 SCC page 150 and consider it at the appropriate time. With the aforesaid observations finding no warrant to interfere in the case at hand, the petition stands.
My apologies, madam. I thought it was the writ petition under 227. It's under 226. In fact, I would have been a little more vocal if I had seen that it is 227. Yes, you have all the issues. Obviously, Your Lordship.
Number 11, Seema S. Nayak, Ambikandi.
Petitioner counsel 6 months. Weeks accommodate. She is not well. Next week.
Please.
Any date?
List the matter on 11th December.
Please.
Yes.
Silma 12, MS Harvey. Manoj Jain.
Please. The case of compulsory retirement, my lord. They have filed appeal before the appellate authority. Before the appellate authority, they have taken a contestation that the appeal is not maintainable.
In the connected writ, I am the petitioner. The MS Ramaya, Your Lordship.
The 94, page 94.
Yes, Your Lordship. It was cloaked as a punishment punitive in nature. I conducted an inquiry. I received a complaints regarding non-completion of syllabus and sending the students to market, holding his bags and sleeping in the classrooms. He put the reputation of the education institution at peril. And moreover, it was continuously for 2 to 3 years, Your Lordship.
You are the institution, is it?
Yes, I am for the institution. In the connected writ petition, I am the...
What happened before the EAT?
EAT, Your Lordship, he did not prefer appeal before an EAT. He preferred appeal under 94(5) before a competent authority.
What happened?
Wherein I contended there that since it's the wrong jurisdiction, let him prefer an appeal before EAT. Wherein the competent authority did not consider that. In fact, Your Lordship, there was a 4 years delay in challenging that inquiry. Neither he filed an IF4 delay, he did not, the competent authority did not pass any order for condonation of delay. Wherein I preferred an appeal before 131 against that competent authority order, wherein even competent authority did not consider my pleadings.
That is what is challenged here.
Here, Your Lordship, the appeal preferred under 131 as well as the order passed by the competent authority.
Yes, sir.
My contention is my section 94 of the Karnataka Education Act is very clear. For a moment,
compulsory retirement
barala. Section 94, my lordship.
The dismissal, removal, reduction in rank.
Three categories of punishment. Then appeal.
As per in the MS Ramaya case, what they have observed is when the punishment is cloaked in a nature of a punitive nature, then very inquiry report can be unearthed by only by the EAT, not by the competent authority.
Inquiry madadra.
Inquiry madidvi. He
inquiry madadra.
He attended the inquiry and asked for apologies. And in fact, he had given me a VRS stating that I'm mentally ill. I cannot teach the students.
So you're only on that interpretation.
Interpretation.
And he
both the authorities have held that no inquiry has been conducted. Madam,
Enquiry is not conducted ಅಂದ್ರೆ 8 till they will hold enquiry.
ಅಲ್ಲ ಅಂದ್ರೆ ಏನಾಗಿದೆ ಸೆಕ್ಷನ್
If at all enquiry is not conducted, it's an administrative action has been taken against him.
ಆತರ ಅಲ್ಲ, enquiry ಆಗಿಲ್ಲ ಅಂದ್ರೆ
Enquiry ಆಗಿದೆ sir.
ಈ 8 till enquiry ಮಾಡ್ಬೋದು, ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬೋದಲ್ಲ.
Produce the enquiry report along my petition. In fact, he has attended the enquiry.
No, compulsory retirement ಬರುತ್ತೆ.
Yes,
So far as other the penalties are concerned, section 94(5) of criminal education, there is appeal remedy other than those mentioned in the section.
Correct. That is why you went there. Clause 4 of MS Ramaya.
Yes, sir, clause 4 of the.
Section, madam, division bench of this.
Even MS Ramaya case, there was a termination simpliciter. That was the allegation. In termination simpliciter and as well as the compulsory retirement, they are not stigmatic punishments, your lordship.
Compulsory retirement.
Sorry, your lordship. Termination simpliciter. It was a non-stigmatic.
Compulsory retirement is a penalty.
And even under allied rules of this K Act, which the petitioner comes under, it is grouped under major punishment, your lordship.
When the act has clearly says that with respect to other penalty, I have to approach the competent authority.
Next Tuesday at 4 p.m. dictating orders. Yes,
please.
ಎರಡಿದೆಯಾ?
That connected matter, the management has challenged the order.
Next.
Number 13, Santosh B. Rao.
Your Lordship, in this matter, the last occasion, Lordship has asked verify whether he has appeared for interview or not, Your Lordship. As is the petitioner is the resident of Ramatirth village, Your Lordship, and respondent number 4 is the resident of the very same village where the notification has been issued. And as per the
ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು, ಮಾಡಿದಾರಾ?
he has attended, Your Lordship.
Documents ತರಿಸಿದ್ದೀರಾ?
Please, Your Lordship. This is the document, Your Lordship, where he has appeared.
Hotel number 6 ಅಲ್ಲಿ ಇದೆ.
ಒಂದೇ ಆಯ್ತು, ಪಾಸ್.
Please.
Next.
14, Santosh Narwal.
Please, Your Service benefits has not been given. In the last occasion, he has given a judgment. It does not apply to this case, Your Lordship. Earlier to this, they have given judgment, Your Lordship, wherein the tribunal under impugning order rightly observed that the petitioner himself has refused the promotion. Here, I have not refused the promotion.
ನೀವು promotion
ಕೊಟ್ಟಿಲ್ಲ.
Promotion after retirement ಬರಲ್ಲ ಅಂತ.
But there is no such clause, Your Lordship.
No, clause ಪ್ರಶ್ನೆ ಅಲ್ಲ. When did you retire, sir?
Yes, sir. I have retired in the year 29/2/2012.
When did you submit your representations?
Earlier to that, I have not.
Earlier to that ಮಾಡೇ ಇಲ್ಲ ಏನು?
ಅಲ್ಲ, ಅವಾಗ
ಮಾಡಿದ್ದೀರಾ?
given, Your Lordship, but it is in their.
In the year 2020, he made an application.
First application.
Yes, my lord.
2020.
Yes, my lord.
Yes. And what is your claim now? Promotion.
Annexure, Your Lordship, Annexure D may be seen out.
Annexure
D, page number 15, is the representation given by the petitioner.
ಅಲ್ಲ. From when are you entitled ಅಂತ?
From 2009, from 29/2/2012. Annexure D may be seen out, page number 15, 15. ಇದು ಅಲ್ಲದೆ ನನಗೆ ಪದೋನ್ನತಿ ಆದ ನಂತರದಲ್ಲಿ ನಾನು ಪದೋನ್ನತಿಗಿಂತ ಮೊದಲು ಹೊಂದಿದ ಹುದ್ದೆಯ ಮೇಲಿನ ಹಕ್ಕನ್ನು ಕಳೆದುಕೊಳ್ತೇನೆ, ಲೀನ್ ಆಫ್ ದಿ ಪೋಸ್ಟ್. ಈ ಕಾರಣಗಳಿಂದ ನನ್ನ ಪದೋನ್ನತಿ ಹಾಗೂ ನೇಮಣಿಕೆ
ಆಯ್ತು. 93 ಅಲ್ಲಿ ಯಾಕೆ ಕೇಳಲಿಲ್ಲ?
ಇಟ್ ವಾಸ್ ಗಿವನ್, Your Lordship, but it is in there. Yes, Your Lordship.
ಇಲ್ಲ, 93 ಅಲ್ಲಿ ನೀವು ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಇದ್ರಲ್ಲ, ಯಾಕೆ ಕೇಳಲಿಲ್ಲ? 1990 ಅಲ್ಲಿ ಯಾಕೆ ಕೇಳಲಿಲ್ಲ? 88 ಅಲ್ಲಿ ಯಾಕೆ ಕೇಳಲಿಲ್ಲ?
Even in the grievance of the petitioner is that, Your Lordship.
Allah, he is not seeking promotion.
Promotion.
Time bound advance.
Yes, sir.
Time scale. Because promotion ಸಿಕ್ಕಿಲ್ಲ ಅವ್ರಿಗೆ.
No, Lordship. There are two reasons, my Lordship, as per Annexure M, my Lordship, that is an endorsement issued by the corporation, wherein, my Lordship, he were to appear for departmental examination. He did not appear for the examination, even though
It has happened during his service. He should have questioned.
on two occasions he did not appear for the examination. And the time fixed by the, that is, state, my Lordship. Thereafter also, my Lordship, he did not make any claim for the arrears, my Lordship. That is only after retirement, that is in the year 2020, he made an application.
Examination has been passed, Your Lordship.
Yes, sir. Anything else? The petitioner is before this court seeking quashment of an endorsement dated 26/6/2024 by which the claim of the petitioner for grant of time, for grant of certain benefits, i.e. the time-bound advancements at 20 years, 25 years and 30 years of completion of service. Heard so and so. The petitioner joins the service of the corporation, respondent Hubli Dharwad Municipal Corporation, on 11/10/1974 and retires as a junior sanitary inspector.
Yes, sir.
Junior sanitary inspector, and retires on attaining the age of superannuation in the year 2012. After the retirement of the petitioner springs the first representation on 12/10/2020 for payment of terminal benefits in accordance with the law. The the petitioner now contends that he was entitled to grant of time scale promotion or time bound advancement for non-promotion for 20 years, 25 years and 30 years respectively. The representation is rejected. Illi court munche bandidra?
Yes, Lordship. I have filed a writ petition before this honorable court.
Representation was not considered and therefore this had approached this court. This court directed consideration of the representation. The consideration has resulted in the impugned order. The learned counsel appearing for the petitioner submits that the petitioner is entitled to all the benefits as he was not promoted for about 30 years of his service and was entitled to that time bound advancement at 20 years, 25 years and 30 years. The learned counsel would further contend that the representation was in detail and the right of the petitioner cannot be taken away. The learned counsel R.H. Angadi appearing for the respondent would refute the submissions of the counsel in contending that the petitioner ought to have agitated during his service and not after his retirement. He retires in the year 2012, for the first time submits a representation in the year 2020, 8 years after his retirement, for a claim that he had lost in service way back in the year 1974 or 76, or even 95 or 96 as the case would be. The learned counsel would further contend that the petitioner ought to have passed certain departmental examinations during his service for grant of those promotions. He has not passed those departmental examinations, therefore there is no warrant of consideration. The learned counsel for the petitioner would join issue to contend that the only departmental examination that he was asked to pass has been cleared and there was no other departmental examination and would seek the petition be allowed and benefits be granted. I have given my so-and-so, therefore narrated so-and-so. The petitioner joins the service on 11/10/1974 is a matter of record. The petitioner after his then 94 ಏನಿದು annexure A?
Annexure is the
the petitioner is then
appointment letter.
The petitioner is then promoted as senior health inspector after 10 years in the year 1994. The petitioner retires from service on attaining the age of superannuation in the cadre of senior health inspector of the corporation. Then submits a representation for the first time. They retires on attaining the superannuation on
2012.
Date another?
2012.
29/2/2012.
On 29/2/2012. The, after 8 years after retirement submits a representation, the first in line in the year 2020, contending that he is entitled to certain benefits of the year 1974 to 1974 onwards till the year 1993. As observed, the first representation is on 22/10/2020. The said representation, notwithstanding a direction for consideration at the hands of this court, comes to be rejected. The rejection of which has driven the petitioner to this court in the subject petition. The learned counsel appearing as contended by the learned counsel R.H. Angadi, for the first time the petitioner submits a claim in the year 2020 for a benefit that ought to have been given in the year 1974 onwards. The reason is non-passing of departmental examination. Whether the departmental examinations were conducted, the petitioner participated, passed or otherwise, is too late in the day for this court to consider, as those are stale claims of close to 40 years. Now the petitioner cannot contend that he must be granted all the benefits, that too 8 years after retirement. The law, it is trite that the law would protect the diligent and not the indolent. The reference made by the learned counsel for the respondent to the judgment of the division bench is apposite. The division bench has held as follows, para 7 and 8. In the light of the aforesaid reasons, finding no warrant to interfere with the claim of the petitioner for grant of promotion, for grant of time-bound advancement for completion of 20 years, 25 years and 30 years of service at the appropriate time, is denied on the sheer delay of the petitioner submitting a representation to the respondent. Finding no merit to the petition stands rejected. Next.
15, Sadiq and Goodwala.
Case of the claim of petitioner is rejected on the ground that there is a delay of 1 year in making the compulsory appointment.
1 year.
Seeking in page 38.
1 year.
1 year is a
Death ಆಗಿ 1 year ಒಳಗೆ ಕೊಡ್ಲಿಲ್ವಾ?
ಇಲ್ಲ, there was a suit pending.
ಅಲ್ಲ, ಏನಾರು ಇರ್ಲಿ ಕಾರಣ, ಡೆತ್ ಆಗಿ 1 year ಕೊಡ್ಲಿಲ್ವಾ?
ಇಲ್ಲ, ಅದಕ್ಕೆ ಇದು ಲಾರ್ಡ್ಶಿಪ್ may kindly see finding by this court in page 31.
ಆಯ್ತು, ಸರ್ವ್ ಮಾಡಿ ಅವರು.
ಇಲ್ಲ, ತಾವು last time they have appeared in page 28 ಅಲ್ಲಿ ಮಿಸ್ಟರ್ ಶಿವರಾಜ್
ತೋರಿಸಿಲ್ಲ, ನೇಮೇ ತೋರಿಸಿಲ್ಲ ಇಲ್ಲಿ ಫಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನೇಮ್ ತೋರಿಸಿಲ್ವಲ್ಲ?
ಇಲ್ಲ, ಈ ಫಸ್ಟ್ ಟೈಮ್
ಅದನ್ನೇ ಕೇಳಿದ.
ಅದಕ್ಕೆ ಅದು ಇಂಕ್ ಪೇಜ್ 28 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಅಪಿಯರ್ ಆಗಿದ್ದು ಇದ್ದಾರೆ.
ಹಂಗೆ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು?
ಮಿಸ್ಟರ್ ಶಿವರಾಜ್ ಮುದೋಳ್ ಫಾರ್ R4 and Mr. R.K. Navalgiri for R1 to R.
Same, ಇಲ್ಲಿ ಯಾರು ಅಪಿಯರ್? Directed to accept notice, petitioner to serve set of papers upon the aforesaid counsel. Yes.
Date. Okay. Can be more short point. This is a finding by this court.
10th December.
Preliminary.
For fresh matter.
Fresh. It can be disposed.
Right.
Please.
Patil.
Short accommodation. Relief of mandamus has been sought in this petition. For the appointment for the post of Urdu language teachers at Maulana, at Maulana Azad schools, notification was issued.
I think problem.
Now, Annexure K in the additional list, the petitioner's names has been included at serial number 9 and 13 at ink page 74. Petitioners were selected. Subsequently, Annexure L has been issued as additional list. Only 6 candidates have been selected. Insofar as Annexure K is concerned, there is no any order passed. Hence, a representation was also given.
This part, sir.
Week's time, secure instruction.
Tuesday. Next Tuesday, week's time. List on next Tuesday and fresh matters list.
Please.
17, MP Hiraman.
The notice issued by
Then ಏನದಲ್ವಾ?
ಇಲ್ಲ, ನಿನ್ನೆ.
Yesterday's matter ಅಲ್ವಾ?
No, this is a different matter.
Election ದ ಇದು?
ಅಲ್ಲ, caste certificate.
ಅದೇನ್ ಕೇಳಿದ್ದು? ನಿನ್ನೆ ಒಂದಿತ್ತಲ್ಲ.
ನಿನ್ನೆದು ಬೇರೆ. That's a different
matter.
matter.
ಬರ್ತಾರೆ ಅದ?
No, your lordship.
Model ಇದೆ.
In the first matter, Lords, notice issued by the respondent number 3, produced at annexure H is called in question. Lords,
ಯಾರು ಸಿ ಜಗದೀಶ ಇವರ?
state, Lords.
Yes, sir.
Please.
He does not have any authority to conduct investigation insofar as the caste of the petitioner is
Who
concerned.
has conducted?
My lords, he has issued a
Who has
notice.
issued?
Respondent number 3, that is the regional fire officer.
Who is respondent number 3?
The regional fire officer.
Fire officer.
Yes,
Yes, sir. Anything else, sir?
that is not maintainable.
Huh.
Second case,
My lords, in second case, my lords,
So first one, hoita.
first one.
The petitioner is before this court seeking the following prayer. The petition heard so and so. The petitioner is appointed as a fire station officer under the category other backward classes as his caste at the time of appointment was notified to OBC as OBC 1. He was posted to work at Dharwad. The third respondent, finding that the petitioner has does not belong to backward class.
No, my lords.
Then what is the challenge?
My lords, subsequently, his caste was notified as OVST in the year 2020. My lords, after that, he obtains a caste certificate and the same is produced. My lords, based on that caste certificate, my lords, I have been promoted.
Oh, that promotion is taken away or what is done now?
Promotion is not taken away, my lords. There was a final.
The on 20th March 2020, the scheduled tribes order was amended and Talwar caste was included as scheduled tribe in entry 38 by substituting the caste therein. The state government then, by an order dated 29/10/2022, removed the Talwar caste from the reservation, from the list of reservation under the backward class category in the light of it being brought under the scheduled tribe category. The petitioner then was promoted, so the petitioner sought and was granted promotion in accordance with law on the score that he was a scheduled tribe. The third respondent then, challenge madlilva?
No, my lords.
The third respondent appears to have issued a notice to the petitioner calling the petitioner for inquiry to inquire into the appointment of the petitioner as OBC, which is now ST, and promotion ST. The learned counsel for the petitioner submits that the third respondent admittedly has no jurisdiction to inquire into the caste status of whether it is a scheduled caste or a scheduled tribe. The learned AGA would, though refute the submission of the counsel for the petitioner, is not in a position to dispute the settled principle that the third respondent does not possess jurisdiction to inquire into the caste status of either the scheduled caste or a scheduled tribe. In the light of the issue revolving around a narrow compass as to whether the petitioner is a narrow compass, whether the third respondent did have jurisdiction or otherwise, the caste status of a person is to be inquired into will be only under the Act. Under the Act, the third respondent is not one of those persons who is empowered to inquire into the caste status of any employee. He is in the nature of the employer. The employer admittedly does not have the jurisdiction to inquire into the caste status of an employee. It should be by the District Caste Verification Committee only, is the settled principle of law as laid down in plethora of judgments. In that light, the notice and all proceedings taken in the aftermath of the notice are a nullity in law. For the aforesaid reasons, allowed, quashed. Next.
Connected matter, my lords. The notice issued at Annexure M is called in question on the ground that, my lords, revision was filed, my lords, against the confirmation of my caste certificate. Without filing appeal under section 4D of the Act, my lords. After the revision is dismissed, they again file an appeal challenging the revision order. That is not maintainable, my lords.
The fourth respondent yaru?
Let's
Private part. Third unrepresented, huh?
The notice was deferred and I was directed to produce the appeal to verify whether the appeal was filed under section 4F of the Act or not. I have produced.
Stay agilva?
It is stayed, my lords, already.
Notice issue mada complainant, and he is the complainant.
He was direct, yes.
yes, he is the complainant.
Yeah.
Respondent 4 is the complainant.
Emergent notice to the fourth respondent returnable by the 12th of December. List on 12th. Interim order subsisting will continue to the next date of hearing.
Yes.
Next.
Till number 18.
I'm sorry, my lord, yesterday, there was some
submission which was factually incorrect. The DE which they claim to have initiated, my lord, is not on the allegations on which I have been suspended. The DE for those allegations has not even commenced.
ಇದು ಫ್ರೆಶ್ ಚಾರ್ಜ್ ಶೀಟ್
ಇದು ಬೇರೆನೆ ಒಂದೇನೋ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಬೇರೆ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿತ್ತು ಅಂತ ಹೇಳಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದೇ ಆಲ್ ಇಸ್ ನಾಟ್ ವೆಲ್ ಇನ್ ದ ಬೋರ್ಡ್ ಹೇಳಿಲ್ವಾ?
This is an eye wash, my lord, only to
hand in glove with the petitioner.
No, not that, my lord. They are preventing me from having the benefit of rule 10(5), my lord. Now it's like substituted punishment.
We'll have to answer 10(5) deeming clause.
Deeming clause.
Because it has far reaching consequences. ನಿಮ್ದೇನೋ ಒಂದು ಸಸ್ಪೆನ್ಷನ್ ಆಗ್ಬೋದು, deeming clause then it becomes. But today charge sheet ಇವತ್ತರೆಗೂ ಇಶ್ಯೂ ಮಾಡಿಲ್ವಾ?
Articles of charge is issued in Lord April 2025. He has not replied also.
No, that's correct. That is not on these. Where is the order of suspension?
Suspension is annexed.
19/12/2022 is the order of suspension.
22.
Page 31.
ಏನು ಸಸ್ಪೆನ್ಷನ್ ಏನು ಇಟ್ರು? ಅದ್ರಲ್ಲಿ ಏನು ಹೇಳಿದ್ದಾರೆ? ಏನಿಲ್ವಲ್ಲ?
ಏನಿಲ್ಲ, there was an inquiry report.
ಸರಿ.
On the basis of the inquiry report.
20 ಕೋಟಿ. Not 20 crores ಕೊಟ್ಟಿರೋದು ಎಕ್ಸೆಸ್, ಅದೇ ತಾನೇ ಇದು?
ಹೌದು, ಬಟ್
ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಏನಕ್ಕೆ ಅದಕ್ಕೆ ಅಲ್ವಾ?
ಇಲ್ಲ ಅಲ್ಲ
That survey number doesn't. One of the cases, my lord, which was, my lord, reported.
Charge sheet is this.
ಅದು annexure, my lord, R3, page number 16.
ಇದರಲ್ಲಿ 20 ಕೋಟಿದಲ್ವಾ ಇದು?
ಅಲ್ಲ
20 ಕೋಟಿ ಒಳಗೆ ಇದು ಒಂದು, my lords. This is one of the payments he has made, and if your lordship, my lord.
ಈಗ ಮಿಕ್ಕಿದಕ್ಕೆಲ್ಲ ಯಾವಾಗ ಇನಿಶಿಯೇಟ್ ಮಾಡ್ತೀರಾ?
ಅದು ಮಾಡ್ತಾರೆ ಈಗ. In fact, my lord.
When do you bring persons to books, sir? Having a siesta here.
Now, one development is that, my lord, the CID has investigated this 20 crore rupees, my lord, matter. They have filed a charge sheet in the, my lord.
ಅದು ಗೊತ್ತು, 23 lakh ಹಾಕಿದ್ದಾರೆ.
Yes. That, my lord, regarding this one payment, my lord, this D is initiated, but original suspension order is in respect of, my lord, 20 crores pending, my lord, D.
My lord, this survey number and this payment does not form part of the inquiry report at all. That is entirely different. On those allegations, no has been initiated, my lord. No explanation is sought. And in this, when I asked for documents, because I was taken by surprise, what the answer comes, we have only 2 documents, rest are not available in this office. And the matter relates to, my lord, saying that the civil court orders release of the amount, I oblige, and the department claims.
On the merit of the matter, when you challenge the charge sheet, we will see.
How that was
now
not.
We are only under suspension.
Yes, that was not part of the allegations in the.
ಇಲ್ಲ, ಈಗ ಅವರು ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕೊಟ್ರ, ಎನ್ಹಾನ್ಸ್ ಕಾಂಪನ್ಸೇಷನ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಪ್ರಕಾರ ಕೊಟ್ರ, ಇಲ್ಲಿ ಇವರೇ ಕೊಟ್ರ?
ಇಲ್ಲ, that land was not even acquired, my lord. It was notified.
ಅದಕ್ಕೆಲ್ಲ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
And it is part of, my lord, the report. Kindly see page number 20 of the writ petition. My lord, the internal report related to, my lord.
Right, we'll answer this deeming clause.
Yes.
Annexure R3 is the,
the first
articles of charge.
On page 20, serial number 1, my lord, ತನಿಖೆ ಮಾಡಬೇಕಾದ ಅಂಶಗಳು ಅಂತ ಇದೆ. ಅದರಲ್ಲಿ ಭೂಸ್ವಾಧೀನ ಪಡಿಸದ ಜಮೀನುಗಳಿಗೆ ಪರಿಹಾರ
ನೀವು ಸರಿಯಾಗಿ ಮಾಡಲ್ಲ. ಅವ್ರಿಗೆ they have a right now to seek deeming clause. Heard reserved.
In fact,
interim order ಇದೆಯಾ?
ಇಲ್ಲ, there is no interim.
Ajay Kumar Chaudhary's case, para 15 and 16, I request my lords to kindly have a look.
ತಮ್ಮದೇ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, my lord. Suspension cannot be a substitute for punishment.
ಇದು ಸುನಿಲ್ ದೇಸಾಯಿ ಇದು.
Yes.
No, this is on a different footing.
Maybe I am only relying on the principle.
Sometimes it is worse than penalty. ಇದರಲ್ಲಿ ಅದೇ ಆಗಿರೋದು. ಎಷ್ಟು ವರ್ಷ ಸಸ್ಪೆಂಡ್ ಆಗಿ?
3 ವರ್ಷ.
ಅಲ್ಲ, subsistence allowance ಕೊಟ್ಟಿ, now D is initiated.
Subsistence allowance ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂದ್ರೆ you have to give. That's a different thing.
True, my lords. The D is initiated already, my lords.
25 ಅಲ್ಲಿ.
25 ನಲ್ಲಿ.
We will observe about that also. Why the discipline authority is keeping quiet for 3 years. We'll see.
My lord, only one submission, my lord. It was stated that the D has been initiated for that 20 crore thing, but the R3 annexure R3 which is
within that 20 crores 1 crore.
illa adralli illa, my lord. What is stated is
Within that 20 crores 1 crore.
Not part of this at all, my lord. And I have obliged the order of the civil court. That is also written there.
Why have you not replied to the charge sheet?
Then I asked for information, my lord. Out of 10 documents, I am given only 2. That to gazette notifications.
ಯಾಕೆ ನಿಮ್ ಇಲ್ವಾ?
ಅವ್ರ ಹತ್ರ ಎಲ್ಲ ಇರ್ತಾವೆ. ಏಪ್ರಿಲ್ ನಲ್ಲಿ ನಾವು ಲಾರ್ಡ್ ವಿ ಹ್ಯಾವ್ ಇಶ್ಯೂಡ್ ಆರ್ಟಿಕಲ್.
ಎಷ್ಟು ವರ್ಷದಿಂದ ಇದ್ದಾರೆ ಇವರು ಇಲ್ಲಿ?
ಅಲ್ಲಿ 2004 ಲಾರ್ಡ್. ಹಿ ಇಸ್ ವರ್ಕಿಂಗ್ ದೇರ್ ಸಿನ್ಸ್ 2004.
As what?
He is my lord first division assistant. My lord, he was in charge manager when this my lord irregularities took place.
ಈಗ
he is under suspension and my lord
ಗೊತ್ತು ಯಾವ ಕೇಡರ್ ಅಲ್ಲಿ
senior assistant ಅಂತಾನೆ ಇದೆ.
ಸಸ್ಪೆಂಡ್ ಆದ ತಕ್ಷಣ ಯಾವ ಕೇಡರ್ ಅಂತಿಲ್ಲ.
ಅಲ್ಲ ಕೇಡರ್ ನಲ್ಲಿ
ಗೊತ್ತು.
he suspension order is as my lord senior assistant.
ಆಯ್ತು.
Great.
ಇದು ಅಪೀಲ್ ಹಾಕಿಲ್ವಾ ಸುನಿಲ್ ದೇಸಾಯಿ? Next.
19, Karthik Ganchari, Shivraj P. Mudho.
Serial number 19, my lords, I appear for the petitioner. This is the matter, I think, I'm sorry, last time I might have missed it, where the learned counsel for the respondent submitted. Is that case, my lords, where more than 4 years after the incident, the proceedings have been initiated. I'm told. I'm sorry, my lord. No, from the, I'm sorry, I should clarify. There are
inquiry. The committee has constituted, inquiry is going on, my lord, and on 18.
There's a stay, my lord.
So far as others are concerned, my lord.
Illa 4 years illa. That ground is not available.
No, my lord, can I just clarify that? I just pointed out, just to resolve any. I'm in your lordship's hands, of course, but I think, my lord, there might be a misconception. My lord, what the requirement of 171B? Could I request? Yes.
Like 4 years illa, it can't be disposed that way. We'll hear it.
Very much. I'm in your lordship.
Just matter on Tuesday next in preliminary hearing. Next.
Bill number 20, Girish V. Bhatt.
Regarding regularization of library supervisor. So, my lords,
yes, madam.
They have filed the statement of objection.
Objection hakidira.
Oh, pleadings are complete. I also produce the synopsis. Facts that, my lords, Annexure A in their 1986, my lord, so 88, a sanction was granted to open the public libraries at Mandal Panchayat level and to open new libraries with a new post.
Library supervisor ಬರ್ದಿದ್ದೇನೆ ನಾನು ಯಾವುದು judgment.
Regularization first, my lords. That was
regularization ಮಾಡಿದ್ದೇನೆ.
I have given the judgment, my lords. Don't library
supervisor ದೇ ಮಾಡಿದ್ದೇನೆ. ಇದೇ ಜಿಲ್ಲಾ like all ಗ್ರಾಮ ಪಂಚಾಯತ್ಸ್ ಲೈಬ್ರರಿ ಓಪನ್ ಮಾಡಿದಾಗ ಅಂತಾನೆ ಮಾಡಿದ್ದೇನೆ.
Sorry, my lords.
We'll take it tomorrow, fresh matters.
Please.
21, Prakasha Surgiri.
I am for respondent number 3 and 4, my lord.
Pay for the petition.
The petitioner has belongs to the 3rd B category, my lord, Jains community. In spite of the
caste certificate.
House only.
They have to file election petition.
No, my lord.
Section 15 of the millets.
ಯಾರು ಏನ್ ಹಾಕಿದ್ದಾರೆ ಈಗ?
ಅಲ್ಲ ಅವರು the present respondents millets 3 to 5
elected, is it?
Elected as a millets president of millets Mugud Gram Panchayat.
Election is over.
Election is over. I elected as a
remaining
president
2
of
months
the,
is there.
let me complete.
Please.
Election petition ಹಾಕಿಲ್ವಾ?
Election petition ಹಾಕ್ಲಿಲ್ಲ. Millets instead of that millets they gave a representation to the assistant commissioner. Assistant commissioner treated as a appeal under section 4B of the millets scheduled caste, scheduled tribes and
Remoter ilva illi?
Yes, my lord.
Remoter illa.
Also me.
Kindly see millets.
Kindly.
Now what happened? Subsequent millets that appeal was allowed. Against that millets I preferred an appeal before the deputy commissioner. Deputy commissioner has confirmed the order. That's in view of the law laid down by this honorable court millets. They have to file an election petition under section 15 of
no,
the
my
Gram
lord.
Panchayat.
No, my lord. I am relying upon this ruling, my lord.
Oh, please.
Please, my lord. Madhuri Patil and S. Bopanna, Lordship S. Bopanna has passed. Madhuri Patil in Supreme Court, my lord.
Patil and A.S. Bopanna.
No, my lord.
Judge sir ಅವರು.
My lord, kindly permit me to submit clearly.
Allah, with regard to
ಏನಾಗಿದೆ
the appointment of service and benefit of admission and all, my lords.
No,
ಇದು
my lord.
election ಇದು.
Kindly permit me to submit that one.
Yes, sir.
Please.
Yes,
Yes, my lord. The petitioner, my lord, who is belongs to Jaina Digambar community, my lord. The Mogad Gram Panchayat president post was reserved for A category, my lord. In spite of that, my lord, the petitioner has obtained a false caste certificate and got elected, my lord. The respond number 3 and 5 belongs to the A category, my lord. In spite of that, my lord, we have challenged his caste certificate before the AC, my lord. Previously, we approached to the Tahsildar, who has taken steps, but he has stick up to his order that, my lord, what I have been already granted caste certificate, that is true on the basis of revenue inspector report, my lord. Then, my lord, we have approached to the AC, my lord, challenging under 4B of the SC/ST and of the OBC reservation appointments of etc. Act 1990, my lord. The AC has authority to cancel the caste certificate, which is already granted, and all in accordance with law has cancelled that one, my lord. Then he approached to the revision. The AC order confirmed by the DC, my lord. Then he approached this honorable court, my lord. Therefore, I have already relied upon the citation, my lord. Honorable Justice S. Bopanna is a very relevant fact, my lord. Kindly permit me to read that one. Para number 2, my lord. The fourth respondent has relied on the caste certificate dated 16/2/2013 while filing his nomination papers for elections to the Town Municipal Council at KGF. The petitioner is aggrieved by the caste status as claimed by the fourth respondent. In that view, the petitioner had filed a complaint to the Tahsildar, which was registered in number CCV CR 31/2013 and 14 by the order dated 21/2/2014. The Tahsildar had set aside the caste certificate dated 28/7/2010, which had been issued to the fourth respondent, my lord. In my case, he has not cancelled, my lord. Kindly permit me to read that one. The paragraph number 6.
AC ಮುಂದೆ ಹೋಗಿದ್ದು ಆರ್ಡರ್ ಇದೆ.
AC ಮುಂದೆ ಹೋಗಿದೆ.
39. Page number 39. Annexure B.
What did the AC say?
Cancelled the
appeal.
Oh, cancel the caste.
Yes, my lord.
Let's kindly see Annexure D before that, my lord. They
You
gave
did not take a contention that it has to be before election petition?
No, let's.
Why?
Don't do.
DC has already confirmed the cancellation certificate, my lord. Now he has approached this honorable court, but his writ petition is not maintainable. He is liable to be punished, my lord.
Well, punished.
Yes, my lord. Kindly see, my lord. Because in Bombay High Court clearly held regarding that aspect. I have produced.
We'll see. Yes.
Kindly para number 2, my lord.
Best.
Please permit
Tomorrow.
me.
Fresh matters. Yes.
My lord,
Let me
remaining
see
2
all
months
this.
is there, my lord. His period only 2 months is there.
ಹಾಗಾದ್ರೆ ಫೆಬ್ರವರಿ ತಗೊಂಡ್ಬಿಡೋಣ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಈಗಾಗಲೇ ಮತ್ತು ಫಾಲ್ಸ್ ಕಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಮೇಲೆ ಇದು ಮಾಡಿದ್ದಾನೆ. ರಿಸರ್ವ್ಡ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಡಿನೈಡ್ ಬೈ ದಿ ಜಸ್ಟಿಸ್, ಮೈ ಲಾರ್ಡ್. ಜೆನ್ಯೂನ್ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್.
Tomorrow, fresh matters.
Tomorrow, please.
KL Patil, Neeraj Reddy Gonde.
Station of seed lead.
ಏನಿಲ್ಲ.
Not sir. My submission may be kindly be recorded.
Go, that I will do, please. The petitioner is before this court seeking the following prayer. The petitioner is the State Bank of India, hereinafter referred to as the bank for short. The respondents 1 to 3 execute loan agreement in exchange of mortgage of the properties of respondents 1 to 3. The borrowers default in payment of the amount and the bank bank instituted proceedings under the SurFaCi Act by issuing a notice on 2/1/2020. A possession notice under subsection 4 of section 13 was also passed by the concerned court. The possession notice was notified. The sale aitala. The bank sells the property in a public auction. The issue is not with regard to the veracity of this sale. The registering authority refuses to register the document on the score that there is a suit pending in OS 272 of 2022 before the concerned court on the objection filed by the fourth respondent not to register the property, and in this suit there is an injunction operating that the parties shall not alienate the suit property. This is what is called in question in the case at hand. The learned counsel appearing for the petitioner K.L. Patil would take this court through the documents appended to the petition, the law in this regard, to contend that the charge under the SurFaCi Act would prevail over any interim order, even the final order passed by a civil court between the parties. He would submit that long after the creation of the mortgage, the suit is instituted deliberately to frustrate the rights of the secured creditor, the bank, and secured creditor, the bank. Be that as it may, even otherwise, the learned counsel submits the registering authority cannot go beyond what is sought to be registered is by now the settled principle of law. The learned counsel for the fourth respondent.
Yes, fourth respondent.
For the fourth respondent would vehemently refute the submission in contending that civil suit is undoubtedly maintainable even against the bank under SurFaCi proceedings, and the order not to alienate the property would include and bind the bank not to sell the property. Therefore, would submit that the petition deserves to be rejected, to await the outcome of the suit in OS so and so of 2022. I have given my anxious consideration. The issue need not detain this court for long or delve deep into the matter. This court, considering identical circumstance, following the full bench judgment of the Punjab and Haryana High Court, has held as follows. Para 2. The learned counsel appearing for the petitioner has now placed reliance upon the judgment of the apex court, places reliance upon judgment of the apex court in Prabha Jain, Central Bank of India, Prabha Jain, reported in 2025 4 SCC page 38. Respondent has placed reliance upon Prabha Jain, reported in so and so. The said judgment is distinguishable without much ado, as the issue there that fell for consideration before the apex court was entirely different. The issue in the case at hand is not whether the civil suit is maintainable or otherwise. The civil court, having passed an order of restraint between the parties, would bind the bank or otherwise. The issue is already answered by the full bench of Punjab and Haryana High Court, which this court has followed, and a direction is issued therein to register the document. In the notwithstanding the vehement opposition of the fourth respondent, I deem it appropriate to follow suit SUIT of the judgment rendered in writ petition 26982 of 23 as quoted herein above. For the aforesaid reasons allowed, the direction is issued to the respondent, the district registrar.
Yes, please, sub-registrar.
Respondent number 5.
Register the document as brought before it in accordance with law.
And quash the endorsement.
Allowed, quashed, Amali direction. Yes, next, please.
23, Vidya, TV Gunja.
After commutation period, as per para 12B, which
Yes,
has been started in
they have to look
2020.
into it. We'll see. List on list on Wednesday. Next Wednesday.
24,
GST matter, Lord. Appeal has been dismissed on ground of delay.
From
the judgment.
Girish will send it back.
Please,
The petitioner
to
is
consider
before
on
this
merits.
court. Yes. Petitioner is before this court seeking the following prayer. The heard so and so. The petitioner is assessed to tax. Certain proceedings are drawn against the petitioner against which the petitioner on communication seeks to file an appeal. The appeal is dismissed on the ground of delay. In identical circumstances, this court, in plethora of cases, has set aside those orders and has with 25,000 costs, set aside those orders and permitted and directed the appellate authority to answer the issue on its merit. I deem it appropriate to follow suit. The observations in the said order is as follows till the end. In the light of the issue standing answered, the petition is disposed on the same terms, quashed, matter is remitted on the same operative portion.
Please, fine on the.
Akil,
Much
Akil.
obliged.
Bill number 25, Renuka, Suresh Gundi.
My Lordship. My humble request is, my Lordship, kindly waiver the suit charge and legal charge, my Lordship.
Suit charge.
Yes, my Lordship.
In waiver model, there is no chance of settlement because they want a total exemption of all the expenses.
This I can't.
My Lordship, petitioner business in completely in loss, my Lordship.
One more
ಆಯ್ತು ನೀವು ಎಷ್ಟು ಚಾರ್ಜ್ ಮಾಡಿದ್ದೀರಾ ಈಗ
1 lakh odd 1 lakh 10,000 ಇದೆ but not only this Lordship,
legal fees ತಾನೆ
ಇಲ್ಲ not only all the legal fees and processing charges surface undertake ಮಾಡಿದ್ದು ಅಷ್ಟೇ ಅಲ್ಲ, there is another case of 1 crore which is
ನಿಮ್ಗೆ ಅದು ಬೇಕು ಅಂದ್ರೆ ಏನೋ ಮಾಡಿ.
ನಾನು ಹೇಳಿದ್ದೇನೆ, they have said that it's not possible. I did it.
We can't issue directions like that.
In fact, I told the manager to settle it. ಅವ್ರೇನು ಎಲ್ಲ exemption ಮಾಡ್ರಿ ಅಂದ್ರು.
ಎಲ್ಲ ಸ್ವಲ್ಪ ನೀವು ಬಿಡಬೇಕು. Settlement is on equal terms. Yes, list after 2 weeks.
My Lordship.
Yes,
next week, my Lordship. 26,
We'll take it on
interim order extended.
Interim order stands extended. Next.
26.
I represent fifth respondent in 26.1, my lords. Request for 26.1.
I appear for the petitioner.
Request for a week time to file the counter.
What's the matter?
My Lord, the 26.1, Lords, I am appearing for the petitioner. Lord, the petitioner is working in the Department of Dentistry, in the third respondent institution.
Department of Dentistry.
Lord, in the third respondent institution since from 25 years. In different positions. Lord, now he is working as the professor in dentistry. Lord, there was only one sanctioned post for the dental department for the professor post. Lord, though my Lord, this petitioner is eligible to hold that post. Lord, since the one professor, Dr. Professor Alnavar was not working in that professor post, he was not waiting to till his retirement to hold that post. What happened? These the respondent, just 1 week before the conducted the DPC proceeding, and wherein they promoted me. But earlier to that, they transferred one respondent number 5 from the fourth respondent institution to third respondent institution, only to made illegal gain of that this thing. And in contravention to the contrary to the transfer guidelines, may I take to the
transfer guideline?
Yes, I will take. First, I will take the annexure H. This is the the order passed by the first respondent. Annexure H. Annexure H.
ಈಗ ಯಾವ petition pleadings complete ಆಗಿದೆಯಾ?
Lords, agilla. R5 I have to file my counter.
May I request thrice my lordship has given the opportunity to them. They did not file. Last date of hearing also specifically stated them that they have to file the objection, otherwise they go on with the matter. In coordinate bench, in similar type of matter, this are they sent back the the transferring institution to the that professor.
ಈಗ who came from where?
The fifth respondent.
From which institutions?
From Gadag, Jim's institution.
Jim's.
Yes. To them, the third respondent, Kim's institution.
Jim's to Kim's.
Kim's, yes. That. That Jim's to Kim's institution.
On whose request?
On his request only.
He has to be placed at the bottom.
Yes, that is the that is my case.
Even
even
ಈಗೇನಾಗಿದೆ?
ಇವಾಗ he is placed me above my, the
That
petitioner.
service is taken note of, is it? The service that is rendered in gyms is taken note of and placed above you here.
No, my lord, that is not. Lord,
Provisional seniority.
may make record. Here transfer itself is not the illegal. May I take notice for a
ಅಯ್ಯೋ
moment?
ನಾನು ಅದನ್ನೇ ಕೇಳಿದ್ದು ಸರ್, ನಿಮ್ ಮೇಲ್ ಕೂರಿಸಿದಾರ ಅಂತ.
ಹೌದು, ನಮ್ಮ ಮೇಲ್
ಅಲ್ಲಿ ಸರ್ವಿಸ್, ಅಲ್ಲಿ ಡೇಟ್ ಆಫ್ ಎಂಟ್ರಿ ತಗೊಂಡ್ಬಿಟ್ಟು ನಿಮ್ ಮೇಲೆ ಕೂರಿಸಿದಾರ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಅಂತ
Yes, Sunil.
ಅದನ್ನು ಹೇಳ್ತಾ ಇಲ್ಲ. That is
Lord,
also
sir.
I am on serial number 134.
In the seniority list of what? Assistant professor?
The professor, he is a professor, he has transferred to the post of professor. But the only, the argument is that not, if internal candidates were available to be promoted within 2 years, there can't be any transfer.
Correct.
Common transfer.
Correct.
Now, because of that, he has been transferred. So he has been.
Now you are eligible for promotion.
Now eligible for the post. Now there is only one post in the professor of dentistry. Now he has been accommodated not by the other things.
ಈಗ he has assumed charge.
He has assumed that he has discharged.
Bloods, I was transferred in March 2024.
But I request serial number 134.
ಇವತ್ತಿರದ
Serial number 134, where I will challenge his appointment itself to the gyms.
ನೀವೆಲ್ಲಿ ಎಂಪ್ಲಾಯಿ?
I'm one of the.
ನೀವು ಕಿಮ್ಸ್ ಎಂಪ್ಲಾಯಿ?
No, I'm not a KIMS employee. I'm one of the applicant to the recruitment process in the gyms.
ಓ, ಯಾವಾಗ ಆಗಿದ್ದು ರಿಕ್ರೂಟ್ಮೆಂಟ್? ಯಾವಾಗ ಆಗಿದ್ದು?
2018. No, the order is provisional. When you see his appointment order.
2019 appointment.
The result of writ petition.
ಆಯ್ತು, ಹಾಗಾದ್ರೆ ಮಾಡಿ 134 ಜೊತೆ ಟ್ಯಾಗ್ ಮಾಡಿ ಇದು.
May I request?
Tag the petition along with 134.
ಅಲ್ಲ, ಇದರಲ್ಲಿ one request. Lord, kindly annexure H.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕದ್ ಬೇಡವಾ?
ಅವರು ಮಾಡೋದು ಲಾಸ್ಟ್ ಥ್ರೈಸ್ ಮಾಡೋದು ದೇವ.
ಈಗ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗ್ತಾ ಇದೆ ಹೇಳಿ? ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇದೆ?
Now Lord, he is not placed above me.
All right.
He is not.
ಏನಾಗ್ತಾ ಇದೆ? ಒಂದ್ ನಿಮಿಷ, ಹಾರ್ಟ್ ಬರ್ನ್ ಬಿಟ್ಟು ಬೇರೆ ಏನಾಗ್ತಾ ಇದೆ?
HODship not assigned to him.
ಕರೆಕ್ಟ್, ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಹಾರ್ಟ್ ಬರ್ನ್ ಬಿಟ್ಟು ಬೇರೆ ಏನಾಗ್ತಾ ಇದೆ?
That not the actually not in fact he has to hold the not the HOD post. Not that post.
ಅದನ್ನೇ ಕೇಳ್ತಿರೋದು ನಾನು, ಅದು ಬಿಟ್ಟು ಏನಾಗ್ತಾ ಇದೆ ಅಷ್ಟೇ ತಾನೆ?
Then not the embarrassment in the institution itself. Not since he is not the senior to not in the same institution. Not he brought not some other institution.
Learned senior counsel Ken Panindra appearing for the fifth respondent seeks a week's time, yet again to file.
Number 3, my lord, KMC.
ನೀವು ಹಾಕಿಲ್ವಾ ಅಬ್ಜೆಕ್ಷನ್? ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, next week.
The learned senior counsel appearing for the fifth respondent and the counsel representing
Lakshman C. Kulkarni. Lakshman C.
so and so,
Please.
seek time, yet again to file statement of objections. Therefore, list this matter on.
I request not.
1 minute, sir. List this matter on Wednesday, the next in the fresh matters list. In the event objections are not filed by the respondents by then, it shall be construed that there are no objections to be filed by the respondents to these petitions. We tag the petition along with serial number 134.
004061 first petition, I am withdrawing the petition.
Thank you, sir.
Memo to that effect.
In terms of memo withdrawn.
Next Wednesday.
In fact, my lord, in similar circumstances, even not.
ನೀವು ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Yes. Please.
It is a case of regularization, Millards. The petitioner was appointed on Millards 27/4/1995 as a literate assistant. The petitioner was appointed as a Millards literate assistant.
Dates ಹೇಳಿ.
1995. Subsequently appointed as a Millards typist on Millards 1/2/1996.
ಆಮೇಲೆ.
And Millards subsequently Millards on various dates, the second respondent has recommended my name for Millards regularization. Let's by virtue of the impugned order. No, the only reason quoted in the impugned order is Millards, a formal order not yet been issued for the post of Millards literate assistant. That is the reason quoted by the Millards first respondent, page number 52 Millards. That issue is Millards squarely covered by your lordship judgment and Supreme Court judgment Dharm Singh.
Jaggu. Dharm Singh. Your
Lordship, as it is not sanctioned post, Your Lordship, and
ಮತ್ತೆ ಎಷ್ಟು ವರ್ಷ ಕೆಲಸ ಮಾಡಿಸ್ತೀರಾ ಸ್ಯಾಂಕ್ಷನ್ ಪೋಸ್ಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಕಳಿಸ್ಬೇಕು
29 years, my lords, last 29
No,
years.
you should send
The
them
appointment order is
ಸ್ಯಾಂಕ್ಷನ್
also-
ಪೋಸ್ಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಕಳಿಸ್ತಾ ಇರ್ಬೇಕು ಇಲ್ಲ ಕೆಲಸ ಮಾಡಿಸಬಾರ್ದು ಕೆಲಸ ಮಾಡಿಸಿದ್ಮೇಲೆ ರೆಗ್ಯುಲರೈಸೇಷನ್
Your Lordship,
ಕೆಲಸ ಮಾಡ್ಬೇಕಾದ್ರೆ ಚೆನ್ನಾಗಿರುತ್ತೆ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಕೇಳಿದಾಗ ಸ್ಯಾಂಕ್ಷನ್ ಪೋಸ್ಟ್ ಇಲ್ಲ ಇವ್ರು ಹುಟ್ಟಿದ್ ಸರಿ ಇಲ್ಲ.
That post is fall vacant from lords 7/12/1993. Till this date, my lords, they have not, my lords, appointed any.
please, as it is typist post, Your Lordship, and the appointment order is also not issued.
ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ ಲಿಟರೇಟ್ ಅಸಿಸ್ಟೆಂಟ್ ಅಂತ ಇವ್ರನ್ನ ಗವರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲ ಇಲಿಟ್ರೇಟ್ಸ್ ಇದಾರ ಕಂಟಿನ್ಯೂ ಮಾಡಕ್ಕೆ. ವಾಟ್ ಇಸ್ ದಿಸ್? ಅಂಡ್ ವೆನ್ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಕ್ಲೇಮ್ ಬಂದ ತಕ್ಷಣ ಹುಟ್ಟಿದ್ದೇ ಸರಿ ಇಲ್ಲ, ಅಲ್ಲಿವರೆಗೆ ಎಲ್ಲ ಸರಿ ಇರುತ್ತೆ. ಬೇಕಾದ್ರೆ ಈಗ ಇಫ್ ಐ ಸೇ ಡೋಂಟ್ ರೆಗ್ಯುಲರೈಸ್ ಬಟ್ ಮೇಕ್ ಹಿಮ್ ವರ್ಕ್ ಅಂದ್ರೆ ವಿಲ್ ಮೇಕ್ ಹಿಮ್ ವರ್ಕ್ ಫಾರ್ ಅನದರ್ 10 years, ನೋ ಪ್ರಾಬ್ಲಮ್. ಅವಾಗ ಎಲ್ಲ ಸರಿ ಇರುತ್ತೆ. ಗವರ್ಮೆಂಟ್ ಏನೋ ಕೇಳಬಾರ್ದು, ಕೇಳ್ಬಿಟ್ರೆ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. ಬಟ್ ವಾಟ್ ಟು ಡೂ? ಪವರ್ ಕನ್ಸೀಡ್ಸ್ ನಥಿಂಗ್ ವಿತೌಟ್ ಡಿಮಾಂಡ್. ಎನಿಥಿಂಗ್ ಸರ್? ಅಷ್ಟೇ. ನೀವ್ ಯಾರಿಗೆ ಸರ್?
Our corporation.
Buddha, you are appearing for Buddha, Your Lordships.
Buddha.
For Buddha.
Corporation.
In fact, he has
recommended. The petitioner is before this court seeking the following prayer. The petitioner heard so and so. The petitioner is appointed as a daily wage employee on 27/4/1995 in the describing him to be a literate assistant. Subsequently was appointed as a typist in the vacant sanctioned post with effect from 1/2/1996. The second respondent, pursuant to in the light of the judgment rendered by the apex court in the case of Uma Devi 2006 4 SCC page 1, the regularization of several employees take place. The learned count, the averment in the petition is that that several of the employees were regularized by the state who were similarly placed. The petitioner, though continued to work as a typist right from 1996, did not find favor with the state for regularization of his services. I had to knock at the doors of this court in writ petition 106545 of 2024, which comes to be disposed directing consideration of a representation of the petitioner. The representation is met with the endorsement that is impugned in the subject petition. The impugned endorsement narrates that the petitioner, in terms of the cadre and recruitment rules, the petitioner could not have been appointed at all, and no formal appointment order has been issued in favor of the petitioner. Nonetheless, he has worked for 30 years now as a typist. The impugned endorsement reads as follows, page 52, 51, 52. It is this that is called in question in the subject petition. If the dates and events are noticed, the dates and events are necessary to be noticed. On 27/4/1995, the petitioner is appointed on daily wage basis as a literary assistant, and on 1/2/1996 as a typist. Even today, in the year 2025, close to 30 years, works as a typist in
second respondent.
In the second respondent. The second respondent, owing to the fact that the petitioner has been working for the last 30 years, has recommended the case of the petitioner for regularization. The state, the learned HCGP now comes up with the objections in support of the impugned order, that there was no formal order passed by the petitioner and he was, as on that day, qualified or otherwise, is not qualified or otherwise to hold the post of typist. As the learned HCGP takes this court to the impugned order, which projects the method of recruitment to the post of typist. Admittedly, the petitioner did not participate in any selection process for projection of a method of recruitment in the impugned order. It may be that the direct recruitment to the post of typist would necessitate the procedure to be followed, but the petitioner has been working as a typist for the last 30 years in the second respondent. When this is not in dispute, projection of a qualification that has come about later, without even referring to the fact whether the petitioner did perform or not for the last 30 years in the cadre of typist, The impugned endorsement does not hold water. Not holding water would lead to its obliteration. In the light of the law being clear, pursuant subsequent to the judgment of the Apex Court in the case of State of Karnataka versus Umadevi, in the cases of so and so. The Apex Court in the case of Dharam Singh versus State of Uttar Pradesh, 2025 SSC Online SC 1735 has held as follows. Allowed cost, the petition, case of the petitioner shall now merit consideration for regularizing his services in the case of typist within an outer limit of 12 weeks from the date of receipt of the copy of the order, bearing in mind the observations made in the course of the order. It is needless to observe that the respondents would not drive the petitioner yet again to this court on the same cause of action.
Next. Number 28.
Lords, 28 is the matter which was listed yesterday. Turbine matter, my lords, wind turbine, windmill.
Energy versus energy.
Is appeal.
Please.
Senior is appearing.
Mr. Pramod Nair on my side is appearing.
Yes.
Pass over. 2:30 I'll take it sharp.
Please.
9. Arvind Kulkarni, KL Patil.
The suspension order is under challenge, which is covered by judgment of my lords. I have placed it on record also.
KL Patil. Pass over.
Sunil Desai's matter where my lords had passed the order.
Lokayukta.
Please. There it was Lokayukta report. Here it is police department report. That's all.
Pass over.
Number 30. RM Javed.
My lord, today's time required for to give the report.
Lordship may kindly see my order sheet dated 29/10/25 in the connected matter.
I have to submit a report, my lord.
29/10/25. My lord, in this managing committee members are out of jurisdiction. They does not come in the.
Oh, four new.
I am submitting.
Lordship may direct for hold of fresh elections, my lord.
Short accommodation 2 days.
Elections
ಮಾಡಿ ಅದಕ್ಕೇನು ತೊಂದರೆ ಇಲ್ಲ. Whoever comes let them be elected.
Absolutely not, my lord, because election has been conducted fairly, my lord, and these 11 members who have been selected they are resident of the localites. On the contrary, my lord, petitioner as outsiders.
Tuesday in the fresh matters as a last chance.
Please.
Yes.
Much obliged.
Next.
Please.
31.
Seeking appointment and compensation. LIC Maladi. They are insisting Maladi NOC from.
Date of death.
Date of death Maladi 25/2021.
Consider Madel once.
Maladi insisting for Maladi producing Maladi NOC from the other family members Maladi.
This son ido.
Son.
Yes, he is first entitled. Other family members bit pudi. Who's your employee?
Father.
Father. Name ಏನು? Nomination
Puttappa is.
Nomination ಏನಿದೆ?
But he had 2 wives.
You let him have more than that also.
Yes.
Now nomination ಏನು?
That we requested the petitioner herein to produce the no objection certificate from all legal heirs.
Why?
Why? Because my lord, the second wife had children are there.
One ನಿಮಿಷ sir. Have you a doubt that he is the son?
No doubt.
ಇಲ್ಲ ಅಲ್ವಾ?
ಇಲ್ಲ. And my lord, in the succession P&SC case, he has shown that she is entitled for monetary benefit, and we have disturbed also. The amount is distributed, except not she lodged a complaint with the respondent corporation saying that she has not consented for compassionate ground appointment. That too, my lord, petitioner's sister has also filed the objection.
Sir, sister entitled, son entitled.
But let him produce no objection from all the legal heirs of the deceased.
No, ಆತರ ಆಗ್ತಾನೆ ಇರುತ್ತೆ. ಆಮೇಲೆ 10 ವರ್ಷ ಬಿಟ್ಟು ಕಂಪ್ಯಾಷನ್ ಹೋಗಿದೆ ಅಂತೀರಾ?
ಅಲ್ಲ, ನಾನು annexure are to produce as per our set of rules.
ಏನಿದೆ ರೂಲ್ಸ್?
ಇದೆ.
ಕೊಡಿ.
LIC employees rules ಕೊಡಿ. ಅದರೊಳಗೆ
ರೂಲ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ಕೊಡಿ.
ಅಲ್ಲ, ರೂಲ್ಸ್ ಅಲ್ಲಿ he must get the no objection from all the legal heirs of the deceased employee. Otherwise, it will.
But he will get.
Let him produce and we will process it.
There is no Maladi.
Unless he produce no objection.
Rules 21 Maladi, page 14 Maladi onwards.
But unless he produces no objection, we can't process the
application. In favor of near relatives to an employee who dies and so and so. Which rules are?
21 rule 21 Maladi subsequent.
And there only other sub rules ತುಂಬಾ ಇದೆ.
Then mal page 15 ಅಲ್ಲಿ ಇದೆ.
Page
15 Maladi. A widow may be allowed to up to 5 years Maladi, the major son and unmarried daughter who satisfy the qualification for apartment and compensation. maybe allowed to up to 2 years for qualification.
ಎಲ್ಲಿದೆ ಬೇರೆಯವ್ರದೆಲ್ಲ ಕೊಡ್ಬೇಕು ಅಂತ ಇನ್ನೊಂದು
ಅಲ್ಲ, ಇಲ್ಲ.
ಅದೇನಿಲ್ಲ ಆ ತರ.
But
All
before
the appointments will be reported zonal office, yes. ಈಗ ನಾಮಿನಿ ಯಾರನ್ನ ಮಾಡಿದ್ದಾರೆ? ಸನ್ ತಾನೆ? ವೈಫ್ ಅಂಡ್ ಸನ್.
wife and son.
Anything else, sir?
And that apart, my lord, what happened is, when we made a communication requesting him to produce no objection and other required documents, immediately he filed a writ petition. Let him produce the required document. We are going to process
In terms of the rules you consider. Extra ಏನು ಕೇಳಬೇಡಿ ಅವ್ರಿಗೆ.
And
Daughter
to what happened is, the second wife is not having one unmarried daughter, minor daughter is.
ಈಗ daughter is entitled a son first preference ಅಲ್ಲಿ.
Of course, son.
ಮತ್ತೆ
For that reason only, no objection from other here.
ನೀವು ಹಿಂಗೆ ಬಿಟ್ಬಿಟ್ರೆ third wife will come. Yes. LIC ಅಲ್ವಾ ಅದಕ್ಕೆ?
But we consider in accordance with law.
The petitioner is before this court seeking the following prayer. The petitioner is the son of one Puttappa. Puttappa was working as,
Branch manager.
Branch manager.
In the Life Insurance Corporation of India, a LIC for short. He dies in harness on 20th May 2021. The petitioner then submits a representation seeking appointment on compassionate grounds on the score that he is entitled to under the extant rules. The representation does not merit consideration on the score that there are several civil suits pending. There is a civil suit pending between there is a dispute between the first wife, the wife and the alleged second wife with regard to distribution of the terminal benefits and claim for appointment on compassionate grounds. The learned counsel, Dharwad, takes this court through the documents appended to the petition to demonstrate the right to compassionate appointment always rests with the family of the deceased, and the family that of the deceased as found in the nominee is the petitioner and his mother. The petitioner is thus entitled to consideration on compassionate appointment is a submission. The learned counsel for the respondent Narayan Yaji, appearing for the respondent, would refute the submission contending that there is a proceeding in P&SC 3 of 2023 which is disposed on 3rd January 2024, where there are rival claimants with regard to the terminal benefits or the compassionate appointment as the case would be. He would submit that the terminal benefits have already been distributed in terms of the P&SC 3 of 2023, but the compassionate appointment is not considered on the score that the no objection is not produced. No objection of all other persons is not produced. In the light of the aforesaid circumstance, the issue now would be, I have given my so-and-so. The issue now is whether the petitioner would be entitled to be considered for appointment compassionate grounds or otherwise. The right of the petitioner is under the rules. The rules are as follows. Page 15 of the Statement of Objections. The rules are indicative of the fact that the appointment on compassionate grounds should be considered of the major son, unmarried daughter, who satisfies the qualification appointment. Unmarried daughter is not the issue in the case at hand, a major son, the petitioner. If the son is entitled to be considered for appointment on compassionate grounds, the respondent corporation cannot now contend that he has to get the no objection from all and sundry, or the all and sundry, I mean the other members of the family, which allegedly is out of the second marriage of the deceased employee. In that light, the petition deserves to succeed. Allowed, a direction is issued to the respondent to consider the case of the petitioner strictly in consonance with the rules within an outer limit of 12 weeks from the date of receipt of the copy of this order. Well, madam.
Please. Lordship's kind permission. Serial number 29. Serial number 29, my lords. I'm filing my statement of objections today, my lord. Lordships, I kindly have it on Monday.
Same matter.
We'll take it. 2:30.
Let's, may I,
Passed over, my lords.
let's, one submission, my lords.
Monday edition. Madam, serial number 29 on Monday. Monday edition ಆಯ್ತು.
Madam,
ಅವತ್ತು ಲಘು ಮುಗಿತದ ನಿಮಗೆ ಮಂಡೇ ಲಘುನ ಬರ್ತದ.
76,
76.
adjournment ಬೇಕಿತ್ತು.
ಕರೆದ್ರು ಸಾಹೇಬ್
Madam,
ಬರ್ರು ಕೂಡ.
Prashant F. Gowdarga.
Ha, yes, ma'am. Madam,
Next week,
serial
madam?
number 36, 2 weeks.
2 weeks. Okay, madam. Madam, petition council ಗೆ inform ಮಾಡ್ರಿ.
Ha, ma'am. Madam, serial number 36, petition Friday ಹಾಕೊಳ್ಳಿ madam.
Serial number 56.
36,
36.
ಫ್ರೈಡೆಗೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ.
ನವೀನ್ ಕುಮಾರ್.
ಹೌದು ಮೇಡಮ್.
ಫ್ರೈಡೇನಾ ಮೇಡಮ್?
ಫ್ರೈಡೆ ಮೇಡಮ್, ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಇವತ್ತು ಎಂಗೇಜ್ ಇದ್ದಾರೆ ಹಾಗಾಗಿ.
ಓಕೆ ಮೇಡಮ್.
serial number 45.
Please, thank you.
serial number
ಮೇಡಮ್ ವಾಯ್ಸ್ ಕೇಳಿಸುತ್ತಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್?
ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸ್ತಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್